Yeah, exactly, right? Yeah.
Exactly. All right, just sort of taking a roll here. We've got Ashley, and Ashley, are you with TJ Pine Valley Place?
Yes,
All right, Mr. Sickle, you're here on that case as well?
I'm here on the 2 matters for Golden Pond Estates.
All right, those are also forthwith. Kelly Cantrell and Joan Gritzmacher, neither of which are here yet. The Watsons are here for the 920 case with Mr. Larkins. And so we'll let things settle here. In addition to all the other fun stuff going on, some pipes burst in the courthouse yesterday. Well, actually over the night. Wednesday night into Thursday morning, and flooded part of the district court offices, including my office. My office has about 10 blowers in it. The carpet's all wet, and there's stuff stacked all over the place.
Oh.
So I'm gonna operate from in here. Laura, did you give me that petition on Stroop? Oh, maybe it was emailed. There it is. It was in there, but I will make it part of the paper one, part of the fund.
good morning, Your Honor.
Good morning.
I think you may have seen that Attorney Larson and I were on the phone in anticipation. I know that you were
Well,
looking.
there's more going on here.
Yeah, I caught that just a second ago.
At about 8:30, the staff asked me if I would do a mental commitment hearing in absence of Judge Kane, who's about to go on a warm weather vacation. I thought he was already left. I said, well, who is it? I want to know. Well, it's Kevin Stroop. Pivotal, our local mental health agency for St. Joseph County, is filing a petition for a pickup order for Mr. Stroop.
They contacted me yesterday, Judge, so I am
You're aware of it?
I knew that was on their list of possibilities. I didn't know the status of it.
Well, for Miss Larson, I'm not gonna, as we all know, Mr. Stroop has been suffering from paranoid schizophrenia and has been an active client of Pivotal for several years. This case got a long, complicated history. We had a,
Judge, should you call the case? Or?
yes, I'll call a case. Thank you.
Yeah.
Thank you. It's TJ Pine Valley Place versus Kevin Stroop. File number is 252656LT. Attorney Joan Larson is here on behalf of TJ Pine Valley Place. She's had a history with this file. It's very helpful to have the same lawyer in these complicated cases. And Meg Bauer is here from Legal Aid on behalf of Mr. Stroop. He has had a perpetual and long time bed bug problem at his apartment, and the complex has been trying to remediate it for several years. We had a consent order which didn't work, and the plaintiff attempted to enforce the consent order with a termination of tenancy. Defendant's counsel through Ms. Bauer objected. There were some technical issues regarding doing it as a violation of the consent order. So it was agreed the plaintiff would simply refile a termination of tenancy, which they have done. And this is the first hearing in that regard. As I mentioned, I was asked to do a mental pickup commitment hearing this morning as a cross-sworn probate judge. We're all sworn to cover for each other when we're gone. And I'm the judge that does the mental health pickup hearings when the probate judge is gone. I do, I don't know, several a year. And very often I already know the people because they're connected to district court cases, and that's the circumstance here. I won't go into the details, but Mr. Stroop is in very poor physical condition. He's not cooperating with mental treatment. His apartment is filthy. He's filthy. And I think he just wants to die.
He is still receiving his mental health medication, as far as I understand.
All right. Well, at any rate, there's a hearing at 9:30 in the probate court. Judge Kane elected to do it himself before he leaves on his trip. So this is a just cause termination for the reasons I stated, a long-term problem with bed bugs in this apartment and other issues. My hope was at some point Pivotal or another agency would find alternate housing for this defendant, but he's very difficult. He's very difficult to place. I'll leave it at that. So this is a first hearing. Ms. Bauer's got a very good grasp of the circumstances, and so does Attorney Larson. So we need to set it for a second hearing. Ms. Bauer, do you have any further insight on this?
I know that Pivotal has worked on trying to find alternative housing, but there are a number of barriers, including some questions about the voucher. Ms. Larson did inform me this morning that he may have his voucher back, but that doesn't align with my understanding of how vouchers work. So I'm curious to get more information about that. At any rate, the defense would object to the allegations that they rise to just cause, and that that he has acted as they have alleged he has acted, just for purposes of covering an answer here. But we certainly don't know what's going to happen with him at 9:30 this morning, and
well, we need to set a second hearing.
Answer.
And as I indicated, when we were in the context of non-compliance with the consent order, there were some very technical requirements that the defendant claimed needed to be met. Now it's just a general termination of tenancy for just cause going back several years and the whole broad context of what was what. But I still expect this isn't going to go quietly.
Your Honor,
Yes, Ms. Larson?
I do want to let you guys know that there is a condemned sticker on his door. We did take over the property not that long ago, so I personally don't know a whole lot on behalf of Mr. Stroop, but there is a condemned sticker on his door. And Chief Hayden called yesterday and said he had went and told him that he was not supposed to be there, and he simply said okay and shut the door in his face.
Judge, first, that was not Miss Larson. That was someone I'm not familiar with who that was.
All right, well, that's,
The
why don't you,
property manager,
Ashley, why don't you go ahead and state, Ashley, why don't you state your name for the record?
Ashley Kasner,
And what's your position there?
property manager.
And Judge, my understanding is that this property was sold in December. I was on the phone with Mr. Stroop when Fire Chief Mike Hayden knocked on the door. He was operating in fire chief capacity. So I was actually there.
Well,
for the
he's not just the
interaction.
fire chief, he's also the zoning enforcement officer.
That's
He's a
why I
fire
said
chief
in that
in Colon,
capacity.
and Constantine, he's the building inspector. Oh, this is Constantine, so I'm not sure what his capacity
Well,
was.
I spoke with him, Judge. I spoke with
Okay.
him while he was there speaking with Mr. Stroop, and I spoke with him after the conversation with Mr. Stroop. But I can represent as an officer of the court that he absolutely did not slam the door in Officer Hayden's face because the three of us had a conversation together yesterday.
I don't think she said
Officer Hayden
slam.
was there because Pivotal called 911 to attempt to get him to leave with EMS. He declined medical service. And in fact, Officer Hayden expressed to me that he made very clear to Mr. Stroop that he was there in his capacity as fire chief and that he was not
Your
trying
Honor,
to
I have to
remove
object
Mr.
at this
Stroop.
point to Ms. Bauer putting in conversations that I was not a party to.
Yes, we're getting all over the place.
Well,
We're gonna have a second hearing on this place. At some point, he's gonna have to get out of there. The properties, we now learn, has been condemned. And so I don't know what the status is. I don't expect this is gonna be straightforward or simple. But because they're trying to find a place to put him.
And
Um,
Judge, I have to advocate for the representations made about him. And so none of this.
Well,
is-
that came out of the blue as in defense of you, Ashley, although it was helpful information to learn that the property's been condemned. And I was unaware of it, and I'll see what further information we can get. All right, I have a wide open next Friday afternoon, but my fear is that's too soon to put this.
in light of the fact that we don't know what's going to happen at 9:30 and there's a lot of voucher questions, I would agree that might be a little soon.
The
I
only thing I
understand
will
the
say,
plaintiff
Your
has
Honor,
an objective though.
well, it's not an objective.
All right,
The only
Ms.
thing I will say,
Larson,
Your
what's
Honor,
your position?
I am leaving my office effective next Friday and going to work for the court. The Ingham County Friend of the
You're
Court.
going to work where?
Ingham County Friend of the Court.
Oh, okay, congratulations.
Congratulations.
Thank you. So I will be leaving private practice. My last day is actually next Friday. If there's any way that hearing could be done via Zoom, I think that, I mean, this case has lingered for a very long time, Your Honor.
I apologize, but we aren't gonna be able to do this next Friday on your last day. Some poor other associate's gonna inherit this, but I'm gonna set it for 1 o'clock, 1:15. For February 13th. By Zoom. We don't know what his medical status is. We don't know what his pickup status is. We don't know what the condemned status is.
Your Honor,
Yes.
would that be scheduled as a second pretrial or is that going to be the actual trial date?
Well, let's call it a second pretrial. I'm not sure we'll be ready to take testimony. I've got the whole afternoon. Well, the problem is this keeps going and going and going and this condemned. So let's set it as a trial regarding termination of tenancy.
That would then be in person, Judge?
Generally, in person is what I do for testimonial trials.
And that
Every
is-
time Mr. Stroop comes, we have to spray for bed bugs after he leaves. His health, I'm guessing he'll be able to be here. Now, you also mentioned there's new ownership of Pine Valley Place,
Yes, Your Honor.
but the new owners, I think, want the same owners were.
Yes. And I know, Your Honor, if we have to get into witnesses as far as the exterminator, she is not local. She's like 2 or 3 hours away, and so are all of her crew.
I'm going to allow this one to be by Zoom for all concerned.
Your Honor.
For purposes of the record, the defense objects to remote testimony.
All right. And you can preserve that objection. Things may change in that amount of time as things develop with the mental health case and his medical conditions and the condemnation. Their case in chief may be the fire chief came, inspected the property and condemned it. We wish to terminate his tenancy because the fire chief has condemned the property. That takes out bed bugs, a whole bunch of other stuff. But we'll see where we are. Certainly, I'm willing. I know you guys have been talking about this case. Ms. Larson, best of luck to you. You've always done a fine job representing your clients here. This has been a particularly difficult one.
Thank you
But
very
we'll
much.
continue it to February 13th at 1:15, and whoever your successor is. And let's see what happens today with the mental health case, what happens with his physical health. And before you leave, maybe we'll have more knowledge on how to proceed. But we'll have it scheduled for that date. All right, thank you both.
Thank you, Your Honor.
And Judge, I'll be here for the rest of the docket
All right,
and
thank
the
you.
other cases I'm on.
All right, that puts us a little behind, but we're ready to start our cases. Good morning, everyone else. Let's see who we've got. We've got William Sickle on behalf of Mr. Cromendike for Golden Pond Estates. We have Joan Gritzmacher, who is present. We have Kelly Cantrell, who is present. We have Andrea Watson and Brady Watson here on the Larkins matters. And I don't know that we have Craig, but we're ready to get started. So let's take up our Golden Pond Estates cases. I would also note that Attorney Meg Bauer, our legal aid liaison, is present. It's always very helpful to have her here. The esteemed Mr. Tim George is here for the Larkins. And everybody that is here, Mr. and Mrs. Watson, Ms. Gritzmacher, Ms. Cantrell, you are defendants in a landlord-tenant proceeding. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And as I mentioned, Meg Bauer is here from Legal Aid on our feed. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance and be prepared to pay the $50 jury demand fee, or file a written demand for a jury trial within 5 days, pay the jury demand fee unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted from your residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency in our county, that is Community Action Agency, a housing assessment and resource agency in our county, that is Neighborhoods Inc. Or if you're a veteran, you may be eligible for some veteran services programs. You do not need the information, or excuse me, you've received that information. You do not need a judgment against you to receive help from the places listed above. Copy of the summons and complaint from your case are sufficient. Ms. Bauer, you may be interested in this, Mr. Sickle as well. A judge in Genesee County show caused the Department of Health and Human Services for continuing telling people they needed a judgment before they could get the assistance, and had a hearing and brought administrative staff in there and made a ruling that they don't have to have a judgment. The summons and complaint are sufficient. And as you know, there in your counties, the DHS has been telling them they need a judgment. As a practical matter, we often have a judgment with the actual numbers in it, but one judge took the bull by the horns and had a hearing regarding it. You may be able to reach an agreement with the landlord by going through local community dispute resolution, known as mediation. Both parties are interested, we could set that up. You may be able to reach agreement with the landlord. That means the case would get dismissed, which case the court would assist you, or counsel would file a conditional order of dismissal. Ms. Gritzmacher, would you unmute your microphone? Let me see if I can unmute it at my end. Can you hear me now? I can't hear you. We're off to a rousing start.
Hello, I can hear
Yes,
you.
very good. I can hear you now. Can you hear me?
Yes, I can, Your Honor.
All right, well, this is a first hearing in this matter. I don't have a copy of a lease, but you're a tenant at Golden Pond Estates.
Correct.
And from what it appears to me, this is lot only. You own your trailer, but you rent the lot?
Correct.
All right, the plaintiff contends, and you don't need the whole history of this. Mr. George will have to deal with this at some point. There's a difference of opinion as whether council can file this as a non-payment of rent on lot only. Some judges don't allow it. Many judges don't. The law isn't clear. I do allow it. Because it gives the tenant an opportunity to redeem the property. But if they actually get an order of eviction, all it does is give them the right to remove your trailer off the lot. Mr. Sickle, at the time of pleadings, you show rent to obtain possession at $1,314. Is that correct?
Yeah, it's been updated since then. Ms. Gritzmacher has made a payment here last week. So the updated rent to retain possession would be $1,614 $614.59 with court costs in the amount of $249.20. So the total possession judgment as of now would be $1,863.79.
All right, now is that through January?
That is correct, Your Honor.
Now, in your judgment, you also submitted something, other money due, $300. You don't reflect that in what you just said. The rent is $1,314.59, and then you've got a phantom other $300 in there, and I don't know what that is.
Yeah, those were some repairs that were made, Your Honor. I've got the statement here. I think there's been some skirting repairs. I'm just looking at the ledger. I think that's what it is. I do have Trish, our property manager here. She may have more information as to what's all included in that.
Well, if she owns the trailer, why are you making repairs?
I'd have to ask the property manager, Trish, Your Honor. I'm not sure.
All right, there's some weird fees out here at Golden Pond that have to do with water and some other stuff that I can't always tell what they are from the pleadings. Ms. Gritzmacher, what's your position?
Your Honor, I got behind in lot rent because my bank account got hacked 3 times and I have lost possession of the money, and I'm just getting it back, and I'm trying to get this taken care of. I've never had an eviction notice ever in my life.
All right, well, the law says that I need to continue this matter at least 7 days, which would take
Okay.
us to next Friday. So let's take a look at that. Next Friday is the 30th. Are you available at 10:30?
I sure am.
Next Friday? Are
Yes,
you,
I
Mr.
am.
Sickle?
Yes, Your Honor.
And I have, Your Honor, filled out the papers for DHS to help on the payments of getting me all caught up.
All right. Very good. Now, when we meet next, it will be the 30th of December. I'd give you 10 days, or January, I'd give you 10 days from that day, which would be February 9th or 10th, be the February the 10th. And then there'll be a new month. So there'll be another $400 included in there for February's rent. I can't tell how this is broken down. They show it as $1,314.59. I don't know if all of that is rent, or it also includes these water fees and connection fees and other stuff that they have at Golden Pond. Do you agree with these numbers?
No, I don't, Your Honor. I don't agree on all these extras when a lot of us are trying, and they're $60 late fee to $100 late fee. Us on Social Security or SSI are never going to be able to get caught up. It's
All right,
making
well,
it
you can't
hard.
do it. Some judges allow no late fees. They're all over the map. So, Mr.
Oh, okay.
Sickle, I've had this discussion with Mr. Cromendike. I can't tell how you got to that $1,314 figure. I don't know how
Yeah.
much is rent. I don't know how much is late fees. I don't know how much is water fees. I don't know how much is that sort of thing. So I'd like that number to be broken down when we meet next, rather than just, and all of a sudden there's a $300 repair bill. I don't know what was repaired. She owns the trailer. I don't know if you were repairing your stuff. I'm not sure why she gets billed if you have to repair her water line. Anyway, there's some uncertainty here, and she objects to the numbers. Also, I'd be interested to know if the late fees are in there, and if so, what are they?
Yeah, the late fees are $60, Your Honor. There are some late fees in the rent calculation.
I don't allow $60 late. Some judges, some were doing 100. I did allow 40 and then I went to 50. But this is lot only. It's not even an apartment. The late fees are supposed to be connected to an actual economic loss. And so we may have to discuss that. Anyway, I want a breakdown of what, and Trish, for you as well, I want to know what these numbers are, how you came up with this figure. She's going to have to explain this to DHS for emergency assistance. And it's lot only. So if they get what they ask for, if you don't pay this, you don't have to move out of your trailer. They have to move your trailer. How long's your trailer been there?
It has been here, I want to say 40 years or more. It belonged to an elder lady, and I have been at this lot since 2020.
Well, as a practical matter, they don't do these as a just cause termination, which would apply a different set
I'm
of
not
rules.
sure. Yeah. I'm
Well, it's
not
not
sure,
just this
Your
part.
Honor.
They're all doing this, and so I don't know. We'll let my successor figure it all out. But anyway, couple things. I want a breakdown of how much the money is, how they came up with this figure. You need to contend with the fact there's at least going to be another $400 rent payment due February 1st with some sort of late fee. But nothing is going to happen until we discuss this further next Friday morning at 10:30. Ms. Gritzmacher, I'll see you at that time.
Okay, and it's a Zoom meeting too?
Yes, it'll be Zoom just like this.
Okay, thank you, Your Honor.
All right, thank you.
Uh-huh.
Now, with a just cause termination, the defendant doesn't have the right to redeem the property. It's just cause to terminate because the rent has been late 3 times in a 12-month period. The landlord has the discretion to accept payment, but in that circumstance, the court orders that the defendant has 10 days to vacate and 90 days to move or sell the mobile home. And that law doesn't apply when it's done this way. So we're in the Wild West, and as far as I know, no one has actually removed a trailer from a lot. But Ms. Cantrell, let's talk about your case. We're kind of in the same boat. And let me know everybody that's here. Ms. Cantrell, can you hear me?
Yes, I can.
All right, Mr. Cantrell, in this case, you submitted documentation that the arrearage is $1,932.80 plus other of $124.45 plus cost of $249.20 for a total of $2,306. Is that still accurate?
That is, Your Honor.
And again, that's through January.
That is correct.
And do we know what the other is?
Yeah, there's a couple things. So there are some late fees in here at $60 a month, and we can correct that to whatever number you want that to be, Your Honor. And then there's also some utility charges in here. There's $124.45 in utility charges that were not paid for November or December. That's what
Alright,
the other is.
All right, well, that's straightforward.
Yeah, the
Utility.
rent, the $1,932.80 in rent includes 4 late fees at the rate of $60 a month.
Ms. Cantrell, what's your circumstance here?
Well, I mean, I was making payments on my rent, but they were applying it to everything else. I had my rent paid forward, up until September 1st, but because they just kept taking money out of my prepaid rent, it threw my bills into a tizzy, and I'm still trying to correct it. I've actually been in contact with DHS and Neighborhoods Inc. to get help to get all of this caught up. It's
All
just
right.
hard to do it because they combine the water sewer bill with rent, and most places want those separate.
Yes, this park has perpetually had water and sewer problems for 50 years. And so if I understand, and there's previous cases, instead of applying your money to rent, they were applying to water and sewer costs.
Yeah, instead of keeping it on my rent. And I didn't have a signed lease with them until September 1st of 25.
All right, well, how much is the water?
I don't know because they throw my water bill all over the place. In July it was $240 some, and then 2 months later it was $60.
How much is your sewer?
That's all into the water bill.
Oh, so sewer and water included?
Yeah, and sewer is usually a lot more than the water bill.
All right, well, just as a ballpark, what is your sewer and water per month?
For if I'm basing it off the last 2 months, roughly about $72 a month.
For sewer and water?
Yeah, or less. But they had 2 months, I believe it was either June, July, or July, August. They charged me for 17,500 gallons, and then the next month was 24,500 gallons. I don't see how that's possible for one home to use that much.
They have a third party contractor that measures their water, and it's unclear exactly what's going on out there. And how much of your payment is being applied to water, and I don't know what the last case didn't have a lease. This one, there is a lease.
I signed the
was
lease
signed
back in September because they
Yes.
told us they were gonna charge us an extra $50 a month if we didn't, and I couldn't really afford it.
The lease shows a late fee of $50 a month. We may be able to live with that. Anyway, so you've also applied for assistance. So Mr. Sickle, the 1932 is just rent and 4 late fees?
That is correct, Your Honor.
And when I was talking to Meg, we found 6.
Well, it's-
All right,
correct.
and then the utilities would be the sewer and water bill that we're talking about.
That's correct. Yeah, no, Your Honor, I mean, I will say it's a little bit complicated to sort all that out. I mean, we have one account that they measure, right? So the ledger that I have for the tenant has all of the tenant charges in there. So this goes back several years. So if they get a payment, they apply it to the oldest charge that's outstanding. So it's all lumped together. So to say what's been paid and what's not paid, I mean, it's not quite that simple.
I agree. So they throw some spaghetti at the wall, hope it will stick, and then the tenant's trying to figure out how much they actually owe or what their money got applied to.
Well,
They thought they were
we do
paying
know what,
some-
right, we do know what she owes, right? I mean, the number that she owes is the number she owes. I mean, we can argue about, well, when a amount for $400 comes in, is it for late fees? Is it for water and sewer? Is it for rent? Right, but the total amount that's shown that's owed is what's owed.
Yeah, that's the spaghetti sticking to the wall. Trying to figure out how they got to that number is not always easy. Anyway, we're gonna continue this along with the next case to 10:40 next Friday, January 30th, 2026. Now, Ms. Cantrell, same thing, another month's rent and utilities are going to be due.
Yeah, and my husband works, he gets paid every 2 weeks. I have part of February put up already. His next check, I should be able to cover February and the water bill that comes out here, I think in a couple of days.
All right.
I just have to get the help to get the water that's
Well, those are the
up
numbers,
and-
1,932, 124, 249 for a total of 2,306.45. All right, I could save myself a lot of grief if I just disallowed these non-payment of rent cases for lot only. But for example, you're trying to get financial assistance from DHS and Neighborhoods Inc. You wouldn't be able to do that because it would just.
And you wish to waive that hearing and admit to the violation, the allegations? I do. All right, the court's going to find that you have violated the terms of your ILC and probation. Despite this violation, the court is going to continue you on ILC and continue you on supervision, order you to continue with the treatment that you have already started engaging in, okay?
Okay.
Anything else, Ms. Nicholson?
Hey, Your Honor.
Mr. Perry?
No, sir.
All right, let's get it right, okay?
Absolutely.
All right, good
Thank
luck.
you.
Yep.
Thank you, Judge.
Be a termination of tenancy. That's why I allow it. And I've said this 100 times, the law needs to be fixed either by court rule, by statute, or opinion from the Court of Appeals, but none of those things have happened. So we're in the Wild West. This part of the Wild West, we allow them to do it, but it causes lots of other problems. All right, I will see you next Friday at 10:40, and Mr. Sickle, I'll see either you or Mr. Cromendike. And eventually maybe we'll work all the issues out for this park and go forward from there. All right, thank
Sounds
you.
good. Thank you, Your Honor.
All right, Mr. George is here on behalf of the Larkins, and also present is Brady Watson and Miss Andrea Watson. So Miss Cantrell, I'm going to go ahead and remove, she left. So let me make a note. This is filed as a demand for non-payment of rent. This is a standalone home on South Constantine Road inside the city limits of Three Rivers. Andrea Watson, can you hear me?
Yes, Your Honor.
Brady Watson, can you hear me? Brady Watson, can you hear me? Are you gonna have to unmute your microphone? Mr. George, what's the status here?
Your Honor, I was provided an update last week that the current amount of back rent is $3,575. There's $200 in late fees. That's at $40 a month. Total costs is $234.93. and the total amount is $4,009.93.
That is through January,
Through, yeah, January 15th was the date of the
through
update.
January 15th. All right, so there's gonna be another month calculated in here somewhere. Miss Watson, Mr. Watson, what's your position?
We are trying to save up some money to get it caught up. My husband had lost his job in October, and I found out I was pregnant and was having a really hard time at the beginning of my pregnancy and was missing some work, and my work slowed down. But he has since found a job making more money than he was at his previous job. And I am now back to work. I just went back from a 2-week layoff this week. So we're trying to get it caught up. And the property manager, Caitlin, said we could talk about getting a conditional dismissal of eviction depending on how much we had in court arranged payment plan.
Very good. Well, the first thing we're gonna do is we're gonna adjourn the matter for 7 days. We're gonna adjourn it to next Friday, January 30th at 10:50. These cases are much more straightforward. There's just rent, there's a lease, there's an established late fee, which is reasonable, and their court costs. You and your husband are probably good tenants. It's easier to keep a good tenant in there than to move one out and move another one in. And I did mention the conditional order of dismissal. The Larkins generally work with their clients to try to get caught up. You're both employed. You wish to maintain your tenancy. If it can be worked out, it can have a conditional order of dismissal filed next Friday. Also, on February 1st, another month's rent is going to be due, and the rent is $975 per month. So take that figure of $4,009. What's actually going to be due is about $5,000. So keep that in mind. I don't know if you're asking for any emergency help from DHS or otherwise, but we'll discuss that further. We'll do this again by Zoom next Friday. Yes, you want to say something else?
I have asked DHS for help. They have denied me because my oldest daughter's dad was very abusive, and I don't have any police reports to show them to stop them from trying to make me go after him from child support, because I don't feel safe with him knowing where I live.
All right, well, how about try Neighborhoods Inc. also.
They have told me, and at the time I applied to them, my husband was unemployed, and they told me with just my employment, I made too much.
All right. Well, there is that. You're too rich to be poor and too poor to be rich. All right, well, let's see where we are next week. It sounds like you guys are trying to do the best you can. Mr. George, you have anything to add on this?
The only thing I would add, Your Honor, is that I did file a limited appearance for this hearing only. I don't know whether that's going to expand my representation into further hearings, but I'll get that information over to my clients and make sure that they're aware of the hearing next week and everything that was said at the hearing. Thank you.
Well, I appreciate you're doing some of these. You're seeing perspective of the issues we're struggling with, and we'll see where we go. All right, someone either will be here. The Larkins, Caitlin, their manager, she's also quite capable. But Mr. George is here for today's appearance, may or may not be here for the next one. All right, Mr. and Mrs. Watson, you're good to go. All right, we've got a new group of people that are here, and let's figure out who's who. We got 3 sets of phone numbers, which is hard because I can't tell who's who. Attorney Barta is here for the 10 o'clock hearings. I'm gonna try to do these one at a time.
Good morning.
These phone numbers. All right, just a minute. I'm gonna put some of the phone numbers in the waiting room. So don't go away. I'm gonna put you in the waiting room. All right, so who is left is here by telephone only. Who am I speaking with? Someone is here, your phone number ends in 8028. Who am I speaking with?
Riley Wessel.
There we go.
All right, you're a landlord.
Yes.
If you're gonna do this as a landlord, you should figure out how to do Zoom.
I think she
All
might be
right,
at
stay
work.
with me.
I think she might be at
Uh,
work, Your Honor.
Oh, that's all right. And you're Lacey Grice. Which case are you here on?
I'm here with Riley. I'm the defendant for Riley.
All right, let me look here. That one is set for 9:40. We're behind schedule, so I got both parties on that one. So you stay with me. Let's see who these other two phone numbers are.
The one ending in 2293 is Essman, one of mine.
That is Robert Essman. He's not related to Susie Essman. Mr. Essman, can you hear me?
Yes, Your Honor, I can.
All right, stay with me. I'll bring in the alleged John Bradshaw here. And then we've got a new phone number. 8875. Who's joined us by telephone?
9875, that's Johnny Craig.
John Craig?
Yeah, 9875.
All right, let me give you your name. I don't really like to do these by telephone only, but sometimes that's all we got. All right, everybody that's here, we have a new group of tenants and defendants who are here, and I'm gonna take a minute and advise you and Mr. Barta of his rights as a tenant in a landlord-tenant proceeding. You might need to know this one day, sir. So you are a tenant in a landlord-tenant proceeding. As such, you have the right to hire an attorney. If you cannot afford an attorney, the court would provide information about legal aid assisting you, or could seek other legal assistance. Meg Bauer from Legal Aid is here with us on the feed. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days using the jury demand form, and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you have not paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a federal help for homeless veterans program if you're eligible for veteran services. We did send that information to you with the summons. You do not need a judgment against you to get assistance from the places listed above. Copy of the summons and complaint from your case are sufficient. You may be able to reach an agreement with a landlord by going through a local community dispute resolution or mediation. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed. The court must provide you with this form, or the council would provide that conditional order of dismissal. We're going to finish the Larkins matters. This was set for 9:25. It's now 9:51. We're about 25 minutes behind. All things considered, it could be worse. Mr. Tim George is here on behalf of the Larkins, and John Craig is here. Mr. George, what's the circumstance here?
Your Honor, I was provided a update as of January 15th. The amount of back rent is $1,975. There's $120 in late fees. That's also at $40 a month. Total cost is $170.22. The total figure is
$170 and what?
22 cents, Your Honor. For a total amount of $2,265.22.
And another month's rent would be $875. Mr. Craig, what's your position?
My work slowed down a little bit. I got a little sick during Christmas time. I got COVID during Christmas, and I just got behind, and I was having a hard time. You know, I'm by myself, trying to pay this rent. Scott's been a good landlord, and I've been, you know, trying to keep up my rent. I got behind, man, and I haven't been able to get caught back up.
Have you asked for any financial assistance?
No, I've just been trying to work and, you know, try to do it on my own, but I'm just struggling.
Where do you work?
I work for Hebcon Construction.
Very cold right now. All right, well, the law requires that I continue this matter at least 7 days. And so we've continued the last matter until 10:50. We're going to continue this till 11 o'clock, January 30th, 26 at 11. Again, Mr. George is here by limited appearance. He may be here or the Larkins may be back. The previous tenant who you heard is in contact with their assistant, Caitlin, and they're going to try to work out some sort of catch-up plan, which means they could file a conditional order of dismissal. As you heard me tell her, it's easier to keep a good tenant in there than to move one out and move another one in. This is 214 4th Avenue. I grew up in that neighborhood. I've said this before, it's apartment 2. I learned to ride my bike no-handed on 4th Avenue on that block. I'd ride up and down the street trying to take my hands off the handlebars. I was pretty good at it at one time. All right, well, you need to stay in contact with Caitlin and the Larkins, but we're going to address this further. Are you missing work right now?
We had the day off today. That winter hours are getting a little slow and our work's getting a little limited, but he's trying to keep us busy as best he can through the week.
Yeah, nobody wants to work outside at 4 degrees with a 20 below wind chill. All right, well, if worst comes to worst, you're gonna have to move. When I see you next, I'm gonna add $875 to that figure. And it's gonna make it over $3,000 that you owe in rent, and you either have to pay the rent or move. I would give you a date, which would be February 10th, I guess, to move or pay the rent, maybe February 9th. So anyway, 10 days. 30. Anyway, we'll discuss that further. So my advice, stay in contact with your landlord and their manager, Caitlin. We will discuss this further, and you can appear by Zoom like this again on January 30th at 11 o'clock. All right, sir, you're good to go.
Thank you, Ron. Appreciate it.
All right, Mr. George, thank you. I'll see you hopefully next week.
Thank you, Your Honor. Have a nice weekend.
Nice to see you, Tim. Oh, I missed him.
Oh, he's gone. All right, we've got Mr. Bradshaw. We've
You too,
got Ms. Richmond, and we've got some 10 o'clock civil matters. Mr. Barta, I apologize, we're a little backed up here. So let's take care of our last few of these and we'll see where we are.
Your Honor, may I just ask a quick question?
Yes, sir.
We submitted a fully executed consent order with installment payments to the court. I just want to know if I have no problem.
Okay, in which case?
Capital One Bank versus Carol Ritchie.
We had a flooding incident yesterday and the courthouse was closed. My office is full of blowers and wet carpet and stacked up boxes, and it looks like a crime. Well, it looks like a accidents. I don't know what it looks like.
Sorry,
it got flooded. So I don't have any reason to disbelieve that. So the staff wasn't here yesterday.
No problem.
Elaine, do you see if we've got a settlement in Carol Ritchie? Are you here only on that case?
That is correct, Your Honor.
All right, I'm going to let you go. Plaintiff has submitted executed settlement.
I believe that was faxed at 11:55 yesterday morning.
All right.
Hopefully the fax machine.
I won't make you stick around for that. I'll take you as your word. And so it's just as cold there as it is here, but it isn't flooded. So you have that going for you. It could be worse. You could be in Big Pine Key, Florida, struggling.
I was going to do this outside, but I didn't want to torture you guys.
All right, Mr. Barta, I'll see you next time and we'll look for that settlement order. Thank you.
Have a great day.
I'm working
You know
on
what
it.
you're talking about, Terry? It's really warm up here.
I got a call from Lydia this morning. She's trekking through snow. And she said she was watching her thermometer just go down.
Well, the snow isn't so bad. It's supposed to, a bunch of it is supposed to come. But let's take care of your cases. Mr. Essman.
Yes, Your Honor.
Is here. This is a continuation of file number 252644LT. We determined last week that rent was $2,709.89.
It was on the fax machine.
All right, that order was on the fax machine and I'll execute it here in a minute. So Mr. Bart is good. 170 in cost. We determined that through January 8th, rent was $2,888.91. Miss Richmond, what's the current status?
Well, he made a substantial payment. His rent now is $732.39 through the 29th of January. Court costs of $179.02 for a total owing $911.41.
Very good.
I also have money I'm dropping off tonight too. I just didn't have time yesterday after work.
Okay. Thanks. Thanks, Robert.
Rent here is $167 per week. But I find that through January 29th, rent is $732.39.
That's correct.
Miss Richmond, you always do a good job with these. I don't have to figure out what's what, or was there a hidden fee I don't know about, and you always calculate it well.
Well,
I wish everybody did that. 9/11/41.
Yes, sir.
Mr. Essman, you have 10 days from today to pay that. Today is the 23rd, so that would give you until February 2nd.
I will have it all paid up by then.
I expect you will. No money judgment is
the potential sentence would be at the time. And he decided to cut off his monitor and not appear for his court date. So I think that those discussions really would not be relevant at this point. The state would just ask the court to send him to prison with no opportunity for judicial release.
Anything from probation?
Nothing further, Your Honor.
Mr. Wendell?
Your Honor, thank you. On behalf of Mr. Shad. Oh, you're good. You're good right where you are. Judge, absolutely. He owns this. And I think you'll hear from him why he did it, what mentally he was going through at the time. And I think respectfully, I think it's important for your consideration. Judge, he regrets what he did. He knows it was a terrible mistake. And I think, Judge, that you will hear that from him when he addresses you. Judge, his mother is present in the court today, Robin Dexter. His girlfriend, Caitlin Hearn, is also present. With your permission, they would like to address the court.
Yes, sir.
Thank you. Ms. Dexter? You want her to, okay.
I need to step up here to the podium. If you can just state your name for the court reporter.
Good morning, Your Honor.
Good morning.
My name is Robin Dexter and I'm Raymond's mother. What I'd like to say is that for the record, that Raymond is a good person. He just made a mistake and he holds himself 100% accountable for that. Not only is he a good person, he's a good son. He's a good man. He's a good daddy and he's a wonderful provider for his family. He has a beautiful family and he has a beautiful home. And that I would just ask that you would take into consideration that and that you would show leniency and mercy when you sentence him today.
Thank you.
Your Honor, thank you. Ms. Hearn?
Same thing, Ms. Hearn.
Good morning, Your Honor. My name's Caitlin Hearn. I'm Raymond's girlfriend. I'd like to start by saying that he is a wonderful man. He obviously made a mistake and he holds himself completely accountable for the mistakes he has made. He is a great father. He's the sole provider for our home and our family. And a lot of people depend on him. So I ask that you please show mercy when you make your decision. Thank you.
Thank you. Anything else?
Thank you, Judge. Mr. Shad would like to address the court and explain his actions and why they occurred.
All right.
Thank you.
Mr. Shad?
Go ahead. Would you like him at podium, Judge?
Yes, sir.
Okay.
Good morning, Your Honor. So bear with me for a second because my emotions are high. I just get like that sometimes. I want to say first and foremost, I know that I disappointed you. I disappointed this court. I disappointed my family, and I disappointed myself. You know, you guys put faith in me to come here for sentence, and I didn't do that. It's like, it was just really hard for me to come turn myself in for something. Even though I know I did it, and I wouldn't even call it a mistake. I call it a poor choice, I feel like I really don't know the difference between a poor choice and mistake, but I feel like that's a better word for it, is a poor choice. I feel like a mistake's something that happens once and you fix it. I've made a lot of poor choices over my life. The day before court, I had got high. I just had a lot on my mind, a lot of pressure. I was thinking about like how I was not going to be around my family, what they were going to do without me, how they're going to make a way out here. And the day before court, I got high, and I had full intentions of coming here the day of court, even with getting high. And I freaked out, and the methamphetamines kind of just like put my paranoia at all time, like all my emotions just got real high, higher than they already were. I got high and I messed up, man. There's no excuse for cutting my ankle monitor off. You know, I've sat for days and weeks, even my whole time out on the run with warrants. I thought about what am I gonna say? You know, why the heck did I cut the ankle monitor off? And the only thing I can say is that just the pressure got hard on me, and when I got high, that made it worse. And I just kind of blasted off with an irrational choice and didn't think about it till after, and after was too late. I think that it wouldn't matter if I got 10 years in prison, that the regret that I have from that choice, from this whole case, the whole scenario, the whole situation that happened, I'll have to live with that forever. You know, I'm going to be away from my children. I'm going to be away from the people that look up to me. And this ain't, like right now, I'm not a person that they should look up to. I made some poor choices, and I hope that they never make them. And I don't want to be repetitive, so I just hope that you consider everything I said in sentence. And I'm not asking for leniency. I'm not asking for anything other than just to consider what I said, and I ask for some type of treatment along my sentence if I could get that. That's about it, Your Honor. Appreciate you guys taking the time to listen to what I have to say.
Well, Mr. Shad, you certainly made a bad situation worse by cutting off your monitor and not appearing for sentencing. Had you done that, you would already have served your time and been out getting treatment and getting the help and being with your family and kids. But I don't know, you just compounded the problem. The court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism factors. Under case 41378, the court will order you to serve 24 months in prison on the failure to comply. Ordered to serve 6 months in prison on the obstructing official business, that by law to be served prior to and consecutive to the 24 months. On the criminal damaging 188 days in the Warren County Jail, that to be served concurrent with count 1. Under case number 42815, the court orders you to serve 12 months in prison, that to be served concurrent with case number 41378. Do we have a jail time credit update?
9 days, Your Honor.
You have 9 days jail time credit. Court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you are also subject to a mandatory period of post-release control, which means upon your release, the Adult Parole Authority will supervise you for a period of not less than 1 year nor more than 3 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence by the Adult Parole Authority. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. Mr. Goodyear, do you have something?
Judge, no, I was just listening.
Okay. Now, there may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost.
Judge, there is one thing I wanted to let you finish. I'm sorry. There's a license suspension with the failure to comply. So it's a class 2, 3 years to life.
I'm going to issue a 5-year operator license suspension effective today.
And Judge, do I understand that the aggregate term ODRC would be 30 months with credit?
30 months credit for time served.
Thank you very much.
Thank you, Judge.
Thank you all.
Thank you, Your Honor.
Thanks, Louis.
Thank you, sir.
Matter this time, partial payment will not prevent the writ of eviction. And the date for the appeal is 2/2/26. Pay some tonight and pay all.
Yep.
All right.
I didn't know.
Mr. Espin, you're good to go. I think this one's gonna work itself out.
All right, I appreciate everything, and thank you, Terry.
Okay,
All
thank
right.
you, Robert.
You're welcome.
Not that I really want to make ourselves feel worse than we already do, but I am gonna be in that neighborhood in February. What is the temperature in the Keys right now?
I think it's been chilly. It's been going down to the 50s, but today is beautiful. I think it's in the 70s right now. Larry's getting the boat out.
Maybe the only place in the continental United States that is in the 70s, but all right, Robert and Melissa Grant don't appear to be here. This is file number 252673. Just a minute, let me turn this off. What's the current status here?
Okay, through January, they owe $1,331.56 for rent. $183.65 in court costs for a total of $1,515.21.
They were both personally served. They don't appear to be here. Is anyone here on behalf of Robert or Melissa Grant? And you always send me a judgment. I wish I could train some of my lawyers as well as you are.
It's part of my routine.
Well, you must have been trained by the Bradshaw Law Office, so I don't know. You've got a.
You trained me.
Yes. Total is $1,515.21. The date for the writ, oops, this is a default. They were both personally served as February 2nd. Partial payment will not prevent the writ of eviction. No money judgment is entered at this time. And the date for the appeal is also February 2nd. Do you think that they're going to pay?
I don't know. Sometimes they just show up with $1,500 and get it mostly taken care of. And then they don't pay for a while, and then kind of an ongoing thing.
Well, it's difficult to find tenancies, and it's difficult to find standalone dwellings at these rates. $765 a month for a house is about as cheap as you're going to find in the current market. So you've got a waiting list of people that probably like to rent this. At any rate, I expect what they're going to do is pay this. 3,331.56 in rent through January.
Correct.
183.65, and the total is 1,815.15.21. All right, we got one more to go. Raymond Schwartz is not present. This is file number 252642. This is a second hearing in the matter of Terry and Larry Richmond versus Raymond Schwartz. We determined last time that through January rent was $1,583 plus cost for a total of $1,693.
27.
Am I right? 27.
Yeah, that's the same. He hasn't made any more payments.
Is he still there?
As far as I know. He was a month ago. He's been
He
there
was
a
at the
long time.
conference. Let me make sure he's not here.
Okay. He was
'Cause
there
he was
last
here
time.
He was here last time. I'm looking for Raymond Swartz. All right, thanks. Bye. Yeah, he was physically here last time. He knows what the numbers are. They're the same as we discussed previously, and the same thing. He's caught up in the past. Defined by default that through January, rent is 1,543. 15848 in costs. And the total is 1,693.27. Excuse me. That is due by February the 2nd. No money judgment, partial payment will not prevent the writ of eviction. Of course, February 1st, another month's rent will be due. All right, the defaults do help us catch up on our docket. Now we're only 18 minutes behind.
Good.
All right,
Glad I
Ms.
could
Richmond,
help.
enjoy the Florida Keys and think about us. But that's why you're there, because you want to avoid this. I can't complain. I just had some warm weather vacation myself, so but it's back to it. All right, I'll see you next time.
All right. Thank you. Bye, guys.
All right, this next matter is Riley Wessel versus Lacey Grice. This is a house on M86 in Centerville. Miss Wessel, can you hear me?
Yes, Your Honor.
All right, rent here is $1,000 per month. What's the current arrearage?
For October, November, December, it was $3,000 and then $50 a month in late fees, so it was $3,150. But now we're in January and it would be another $1,050. So it would be $4,200 altogether right now.
Miss Grice, do you agree?
I do, yes.
I do.
I have a little bit of money in my savings that I plan on giving Miss Riley.
All right, well, let's talk for a minute. Let's also calculate the court costs.
Okay.
We got a $55 filing fee and a service fee of $32.20. So the total is $87.20 in cost. Total through January would be $4,287.20. You might as well figure on adding another $1,000 for February before we get to where we get. So, all right, let me back up a minute. You intend to pay some here soon?
Yeah, I do. I reached out to DHS before we even had a court date. You know, I asked them if they could help me. They said the only way that they could help me is if I get a court date. I spoke to Miss Wessel and I told her, you know, like DHS said that they'll help me if we can get a court date.
Well, you've got a court date.
We got a court
So I want
date,
you to share
yes.
this information with them.
I applied to DHS before the court date. They denied me because we didn't have a court date. I've applied 2 separate times, actually 3 now. They denied me 2 times for being in non-compliance for child support. I called the 1-800 child support number. They said that's an error in DHS's system and that they would email them. So then I called DHS and I told them exactly what child support had said and that they would be sending an email. They told me that SER forms are very
like tricky. Once they get denied, you have to reapply. So I reapplied, immediately got denied again for being in non-compliance. So yesterday I spent all day doing the same thing. I spoke with DHS. They said that they are going to submit a ticket, like stating that there is an error in the system so that I don't get denied for being in non-compliance. Like I don't have any open child support cases.
All right, well, we had another lady this morning who had the same sort of issues.
Yeah,
But I'm
heard
gonna
that.
continue this for a week to January 30th, 2026 at 11:05.
I'm trying
I
to
would
get
appreciate it
DHS.
if you could both be by Zoom. If we have to do this by telephone only, we'll do the best we can. Miss Wessel, let me tell you
Yes.
some things you need to know as a landlord. If we have a hearing next week on January 30th, I'm gonna make a finding on how much the rent is, and I would give her 10 days to pay the rent, or she would be subject to being evicted. That would be on February the 9th. You don't have to evict her on February 9th. You have 56 days from that date to ask for the writ of eviction and another 56 days to serve it. So you can work with Ms. Grice to try to get caught up on this back rent. But Ms. Grice, you need to know that by the letter of the law, if you don't pay it, she can move to evict you. She's gonna be $5,000 plus behind. And it's gonna be very difficult for her to collect that. Same thing, she probably has someone that would like to rent this property. And so you need to stay in contact with your landlord.
Yes,
And
absolutely.
but we'll address this further. Share this information with DHS that you're gonna owe $5,287 plus 50 more.
My plan, I had asked DHS to help me with the 3150, and then I can pay January's, and then I'll be able to pay February's and kind of get caught up. I just kind of need help with them paying the 3150.
All right, well, hopefully they can give you some. I
Yeah.
did see your form that you had filed for the assistance.
Yeah.
We'll see this. If we need to adjourn it again, we can, but right now I'll just leave it for that date.
Yeah.
All right, thank you.
Yeah.
Thank you.
All right, we're a little behind, but it could be terrible. Somebody's logged in as mommy. I know that's not their name. Who is logged in as mommy?
That would be my daughter.
Well, what's your name?
This is Randy and Patricia Winters.
All right.
We kind of tired, Judge. We worked all night.
Well, all right, we'll try to get through this.
Okay. How are you today?
I'm all right. It
I
is, it's good to be somewhere.
Yes.
I was
warm.
somewhere warm, but now I'm not. Well, let's take care of our 10 o'clock matter. The esteemed Brian Groen is here for Citibank versus Matthew Ritchie.
Can I get
He's
that in
just as
writing,
cold.
please? I like the esteemed part.
Okay. Well, he and his firm often represent Citibank in these matters. This is a claim for $3,599.12 plus cost. Plaintiff has filed a petition for summary disposition, and the defendant has failed to appear.
Your Honor, he did reach out to our office relatively recently ago and worked out a payment plan. And I've just checked the file and he did make that first payment. We emailed him a proposed consent judgment about, looks like 3 or 4 days ago, and we have not received that yet. But since it's so recent, I'm a little leery of going forward today. I would like to give Mr. Ritchie some additional time, and I'm thinking maybe also mailing him a copy of the proposed consent judgment.
And we had a flood yesterday and the courthouse was closed and we're still struggling with it. So how about if we just continue this to next Friday at 10?
I was thinking maybe a little bit longer than that, Your Honor.
All right, how
because I want
about,
to mail him a
we'll do
copy
it
as
Monday.
well,
You often
so-
come on Mondays. How about if we continue this to February the 9th?
That will work.
To 6 at 9:30 a.m. Expect to receive consent judgment.
So February the 9th at 9:30.
Yes. Defendant has made first payment. That should be enough to get that resolved.
Yep, I will get that out. Hopefully, we send him one, he can sign through, DocuSign. So I'm hoping he does that and we'll get that over to the court. If not, we'll address it at the next hearing.
All right, thank you. You always get to sit in on some landlord tenant cases, probably more than you care to know about, but thank you for your patience. Right now, we're only 18 minutes behind. It could be
You're
worse.
much better off than many courts I deal with, so you're not bad at all.
All right, we do try to start on the time allotted. All right, thank you. I'll see you next time.
Sounds good, Your Honor. Thank you.
All right, now we've got Mr. John Bradshaw here on Quail Run Apartments versus Braden Hirschberger. File number is 252678. I think that was a previous case. This is a demand for non-payment of rent. Rent is $800 per month. The current arrearage is substantial, $58.60. I didn't know how he was served. Let me look. The defendant was personally served and he's not here. Mr. Bradshaw, what's your position here?
So, Your Honor, I also believe there was a second mailing, and the current amount due through the month of January is $6,610. That's $50 for the last 3 months in late fees. We did not ask for a money judgment. So if it pleases the court, I would request a default judgment stating further that the property has been kept fit for the particular purpose of rental property. And to the best of my knowledge, Mr. Hirschberger is neither incompetent, a minor, or in the active military.
All right, so the rent
I'm sorry. Yes, the rent due through January, $6,610. There's $198.40 in court costs. So the total due through January, $6,808.40.
All right, defendant failed to appear, personal service, and second mailing. Maybe he figures just so far behind at this point, he may have to move. Anyway, subject to default, if you email me a judgment, I'll sign it.
We'll
The
do
date
that.
for the writ would be 10 days from today, which was February 9th.
Got it. I'll prepare that judgment and send it off to you.
All right, very good.
Also, I would like to say that I'm probably one of the rare people. I don't mind this weather. As long as it's sunny. As long as it's sunny, I'm good.
You know, I can identify with that. If it is sunny, you know, in Colorado, they deal with much cold weather and it's sunny and people are skiing and going about their business. The only problem is that it freezes pipes and that sorts of things, but which is what it did here.
Yeah, unfortunately.
But if it's cold, it's cold. We'll stay inside and we won't do much outdoors this weekend. I may watch people that are crazy enough to go out and ice fish in this weather, but I'm going to stay in the house. And I went to Lowry's bookstore and brought a couple books yesterday, so I'm in good shape.
All right.
All right, you'll email me that judgment. I'll see you next time. And I don't know if he's still there, but he's got till February 9th to vacate.
Okay, thank you so much. Thank you, Your Honor. And
All right,
good
thank
to see you, Meg.
Thank you, John. For the record, I like the snow. I could do without the cold. I'm all about the snow, though.
Yeah, I like the snow too.
Winter is winter. I guess we're in for a penny, in for a pound, and we live here and
yeah.
If we didn't like it, we could move to Big Pine Key, so I guess we're all right.
The perfect winter for me is 25 degrees, snows every Friday night, sunny on the weekends, and then in March it turns to 60 or 70.
Turns to mud.
I was just gonna say, and green grass immediately.
There you go. All right. Take
Well,
care.
I've
Have a
said
good
this a
weekend,
lot.
Joe.
I would enjoy Michigan fall very much if it was followed by Michigan spring.
Yep. There you go.
All right, I'll see you next time, Mr. Bradshaw. Thank
Thank
you.
you.
All right, now we have a clunker next. We have Vicky DeMeyer versus Randy Winters and Patricia Winters. The Winters were here. I lost them. They've been up all night. Mr. Dutka is here on behalf of the plaintiff. I hope I didn't accidentally X them out here. Good morning, Mr. Dutka.
Good morning, Your Honor.
Yeah, they were here and I lost them. So let's see if they log back in. Now, they had indicated they had contacted Aiden Freeman at Legal Aid and he was going to be filing an appearance, but I don't believe I ever received an appearance from Legal Aid. Did you, Mr. Dutka?
No, sir, no contact as of this morning. Nothing on my email, nothing on my telephone voicemail. I haven't gotten my regular mail as of today, but I'm assuming nothing.
Judge, that would probably be Adam Freeman, and I will
Okay.
look at our system. Hmm. Although I guess I could be mistaken.
Well, they may be mistaken. As I said, they were here. And this matter was set for today at
Actually, 10:30, Your Honor. So
10:30. So we're not there. We're actually ahead of schedule. We got caught up.
and I see Mr. DeMeyer isn't present yet either. So, and I know he was going to call in.
All right, let me take these couple files out here. Good morning. I'll be right back. Tarmac at O'Hare Airport out there. There's 50 blowers and boxes of junk all over the place, and it's relatively quiet and warm in here.
Was it just your office, Judge, or were there multiple offices that the pipe?
Mostly the district court office and the jury room and the probation department. The ceiling collapsed into the lower level, and it's bad down there. They're going to be moving in the courthouse move, so we're just going to move them sooner rather than later.
I'm glad it wasn't a targeted hit, I guess, even though that makes it bigger.
Oh, it was just an old aging infrastructure.
Yeah.
All right, Mr. DeMeyer is here. Have the Winters come back? Mr. and Mrs. Winters, are you there?
Yeah.
Yes, there they are.
Just leave it like that.
Trying to keep my eyes open.
All right, so we've got everybody here. Let me make my notes.
Let them know today was my son's birthday. Wish they would.
All right, this is file number 252647LT. It's entitled Vicky and Randy DeMeyer versus, is it Randy?
Yes.
DeMeyer versus Randy Winters and Patricia Winters. This is a termination of tenancy case. We are here on January the 9th. The DeMeyers contend their house has been trashed and they wish the Winters to move. The Winters said that they had retained the services of legal aid, Adam Freeman. We've not received any appearance or any information from Adam Freeman. Rent was last paid in October of 2026 and none paid since. The lease ended December 4th and the plaintiff simply wishes to terminate the tenancy. It isn't even just cause, it's just expiration of the lease. The Winters also contended they had contacted Fair Housing and I haven't heard from them either. So Mr. Dutka, what's the circumstance here?
Well, I think Your Honor put it in perspective. I think that's what we're basically moving forward with. This is the end of the lease, and it was decided before the end of the lease with the 30-day notice. It just wasn't going to be renewed by the DeMeyers, and I think they had an absolute right to do that. The lease ended. Defendants are still in possession, and I think plaintiffs are entitled to an absolute right to possession.
Mr. and Mrs. Winters, what's your position?
Go ahead.
Go ahead, man.
Sir, we have two leases. I moved in December the 4th. I am aware of that. I got 2 weeks before court a notice to quit, and I felt that that wasn't enough time. And due to the circumstances, I have a lot of things going on. Today I'm shaking because I lost my son. This was the day that I buried my son. He's a United States veteran. And I wouldn't have think that they knew too, because he came to this house and he seen my son on my wall. My son been gone here still like me. Oh my God.
All right, I can still hear you.
Oh my God. Could you just ignore that phone call? Because they trying to reach. No, leave it alone.
All right. Well, they had asked you to move by December 4th and you didn't.
Yes.
And you're still there and they still want you to move. What's your position?
I came in here and I'm not a trashy woman. And it hurts me so bad for them to think of that, Your Honor. And the things that were said to me that is very, very hurtful. I have messages through my phone. I've reached out to Vicky. I've reached out to Mr. DeMeyer with Vicky's number. I have messages. No one contacted me. I've been without a dryer here. I bought a dryer because it went out. I work every day. I've been have to go to the laundromat or hang my clothes up because they don't want to come down here and do the stuff that they need to do. I don't ask them for nothing. I fixed this place up. Me and my military grandson that is a lieutenant now, me and him fixed this place up. They couldn't even get in here for 12 years. And then now they got in here. They see what I have done. They can make money on it. It was told that last year, in June or July, that they were selling this place. Right after I got done with court with you, Vicky started bothering me and harassing me again. I had my family, which is another military person from from New York, came down here. I got my church family here. They had the officers come here. I feel like that is very disrespectful, and I just want apology. I'm asking for time to get out of here. We have 2 leases. That's why fair housing is involved. The police officers are aware. I showed them my proof, and we could go further with this if y'all want to, because I got all the proof, and I am not a nasty woman. I'm a clean woman. I got a cleaning job, honey.
Well, they aren't contending that you are. She said that.
Very
I blurted it out. All right. Stop. They're simply saying, and one of the reasons is we want to sell the house. This happens a lot. The landlord has the house. They want to get out of the landlord-tenant business. Their health is failing. Other things are going on. They want to sell it. In order to sell it, they have to get the tenant out. They give you a notice to quit, saying you got 30 days to move. You didn't move. So they asked you to move by December 4th. That didn't happen. So they filed this action. We have a hearing January 9th. I adjourn it 2 weeks from January 9th to January 23rd. You still haven't moved. And the law now says you have 10 days to move or you're subject to being evicted. So you get 10 days from today.
Your Honor, can I speak?
Yes.
Your Honor, we have 2 leases.
That's why fair housing is involved. Go ahead.
We have 2 leases. You know what I'm saying? My lease and her lease, because she moved in first. So she have her own lease, then I moved in. So I have a lease myself. I wouldn't like to go off my lease. They just can't forge and say, this is my lease. I have my own lease.
All right, well, let's take a look. Randy Winter's lease agreement is signed December 4th of 2024 for a 1-year lease. It's got your signature only on it.
No, my lease was March the 31st.
It's 2-4.
That's what my lease is supposed to. Do you have a paper bag?
2-4.
The lease I have in front of me is one for you, which expires December 4th of 2024.
I got it.
And I have a lease for Patricia, which expires December 4th of 2024. There is 2 leases, but they both have the December 4th date.
No, I'm gonna go further, sir.
I have a lease.
I'm gonna show you the lease. I have proof. This man signed the lease before me. After me.
I signed the lease after her.
Where's my coat?
Right there, your pocket, your keys on there.
Where?
In the room on the table.
Okay. I got the lease. I got proof.
We had a lease right here, sir. We don't have no other lease.
It's a lot.
She have her own lease. I have my own lease.
All right, I agree with that. I've got 2 leases, but they don't both say December 4th.
I know, first, because she moved in before I did. Then I came in March and moved in.
Well, your lease was signed on.
This is why I'm going further with it.
I have a document that I had the same one. I had the same.
I'm sorry. I'm trying to get it out. I have it right here. She switched it. That's why fair housing is.
I can't tell what day it was signed, but it ends on December 4th.
No, it's supposed to end in March.
You have this.
Well, it isn't. It isn't. It says December 4th.
Well, I got Randy's. I got Randy's lease right here. Vicky forged that. And I will show you. I got Randy's handwriting and everything. I got 2 leases, 4 leases, 5 leases. She sent out different ones. I got the burden of proof in front of me. Please give me some time.
Say that again.
Please give me a little time to get it up.
She getting the lease up. The right lease.
The lease that Randy, when he moved in here, y'all cannot do that.
The lease that I signed, not the lease that she gave me. You know what I'm saying? That she made up. The lease that I signed.
We went to court, and Judge Middleton should have the first list that we had on the last one. But I'm looking through here. Hold up, I got it. I got it. I got it, baby. I got it. I really do. This is what the pastor said for us to keep. And I did it. Right here. Hold up. December 4th. Oh my God. They just give me a minute. I'm quickly. I gotta get there. Hold up, I got it. I got it. I need my glasses. Yeah. Here it is, Daddy. I got it. I got it. Here you go, Judge. Where you at? Judge?
I
You
didn't go
see?
anywhere. You're like a cat on a griddle back there.
Oh,
kitten on
I
a
move
griddle.
like that, sir. I move like that, sir. I got 19 grandchildren. I got to move like that.
All right, I
And
didn't.
4 of them is military. 4 of them is military, so I have to.
All
I
right,
have to
well,
move like
so
that.
what are you showing me?
I'm showing you Randy Winter's lease. Burden of
All
proof.
right,
No,
well,
This is Randy Winter's lease. This is what we got when Randy moved in
all
here.
right,
We
well,
got
what
10
is
leases in
it?
here.
When was it signed?
It was signed on. Hold up. We're at 1204. See, it's still coming up. There's that. That's not the one, baby. That's not the one. Get your lease out. You got to
Yeah,
help me.
that's December 4th.
This is December 4th. This is where she tricked. This is where she want to catch us up at. Please, Lord, help me. Here, hold up. Lord, help me. Here, come on. God knows. God don't bless no mess.
No,
Vicky changed
both of
this.
your leases say December 4th.
No, they don't. No, they don't, sir. I will fight this. I will take this all the way. I will
All right,
go
well,
to.
you do
I
have
will
a
go
right to
trial.
appeal it.
Yes, no,
But you
I'm
have 10
going
days to
trial.
move out or you're subject to being evicted.
No, give me
Your-
your
your
lease,
lease
Randy. They cannot do this. Or I'm gonna call the court. I'm gonna call the what's the name? They cannot do this. You got a lease that say 2-4. Vicky changed that. Vicky tampered with that. And the pastor got a copy of it too. That's the thing about it. That's the thing,
Well, I
because they
don't
had to
see
have
it.
it
All
for.
I see is what they filed. You can apply for an order of eviction after February the 9th.
Sir,
This
is
has
not
been going on
true.
for
This is-
several months, several weeks.
No, they're
Your
trying to.
lease is
They're trying to say
expired.
that.
I don't have an escrow order. And both
gotta help
leases
me
were
find
signed
it.
with an expiration date of December.
Your
4th.
Honor, Your Honor, Your Honor, please don't do this. I have proof. Please don't do this. Give me time. I worked third shift. Please give me time to get this lease out. She changed this. She forged this, and I could get her on this. I have burden of proof. She's done so many leases here to mess us up and to flip us. And we got the first lease that when we first went to court, you got it. It's in your what's the name?
All right, well,
I'll
hold it,
email.
hold it.
I'll email you.
All right, please sit down so we can discuss this. You're very agitated.
I'm very because it's
you're
not
stop.
right. They're lying.
Stop.
The blood
Stop.
of Jesus. The blood of Jesus.
All right. There's 2 leases signed by each of you. Both are signed December 4th. So if you contend that his was signed on a different date,
yes,
then I guess I'll kick you out effective 10 days and we can fight about him. But his lease also says December 4th. And the lease that you found also says December 4th. So you have 10 days to move or you're subject to being evicted. No money judgment is entered here. You can appeal this. I suspect you're not going to find a lease with a different date.
Yes, I am.
I think this is the lease.
God don't bless no mess.
And
I
they've been
believe in
trying
God.
to get you to move since early November. You're both working third shift. You need to move. You need to move or you're subject to being evicted.
Okay,
I
I'll
will
tell
send
you
you a
what,
copy of this order.
Your Honor, when I find this lease and I show you, all I want is an apology and that's it. And I want the Myers to know that I made their place the way it is because it was trash when I first came in here. If y'all give me, I will make sure that the carpets and everything and it's ready to go. If you're going to sell it, you sell it. If it's not, God knows. But y'all know y'all not right. If
Well,
y'all
they
could
have
give me
10
until
days. They
February.
don't have to ask for the writ on the 10th day. They can give you up to 56 days to move, but no rent has been paid since October. So you're living there for free right now.
No, I'm not, Your Honor. I have proof.
Of what?
I have proof the last time I paid Vicky was November the 7th. And I went to the
All right,
bank.
well, this was filed on. All right, so you haven't paid any rent since November. So we're now
Because
January,
she said that she wants me out and she
December,
don't want any
January, and
money.
about to be February. The matter was filed with the court on December 9th. So some rent was paid. I don't know if that went to October. I think they said the last month that was paid was October. So, all right.
Your Honor,
Yes.
this is right. This is it. It says 2/1/25. Baby, I can see. Here's the lease, sir. You can put me out. You sure can. But God ain't gonna put me out.
I'm not sure what you're showing me.
This is the right lease. This is the lease for Randy Winters. He was 53 years old when he signed this lease.
All right, well, Randy has an appeal. You don't. Your lease expired December 4th.
I'll leave. I can leave. But you know what? I tell you what, ask the DeMeyers if I
Randy
do
moved
this.
in on 2/2/24.
Yes.
Randy paid a deposit of $480, gave Randy a different lease but the move out date was the same. He did move in on 2/2/24, but the lease he signed expires December 4th of 24.
He didn't sign that lease.
And if I might add, Your Honor, the paragraph she's showing the court gave Randy Winters until February 1st of 2025 to pay the security deposit. That's
and
what
we paid it.
showing. Okay, that's fine.
Yeah, so it wasn't the expiration date of the lease, it was the due date for the security deposit.
We paid it.
All right, Miss Winters, I wish you luck.
Thank you.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
All right.
Doug, can you give me a call after we sign off?
Yeah, I'll call you, Robert.
Mr. Dutka, you provided a judgment. The date for the writ is February 9th. Mr. DeMeyer, you may need to give him some leeway on a move out, but if you're gonna sell this property, obviously it needs to be vacated. For what it's worth, it did not look trashed in the pictures from them. It looked like a decent place, but we'll see. Anyway, both leases expired on December 4th. The notice to quit was 30 days before that. They didn't vacate. December 9th, the action was filed. It's pretty straightforward.
So they need to be out by February 9th.
Or they're subject to being evicted. You can give them more time if you choose to. It's easier to have them move out voluntarily than to evict somebody. But February 9th is the date for the writ. The next day you could contact Sergeant Morse. All right, you're good to go. Thank you.
Thanks, Your Honor.
All right, let's go to our last case of the day. I'll remove Mr. DeMeyer. His name is Doug DeMeyer, not Randy. All right, Ms. Carr, why don't you come up here and you can have a seat right here. Our next matter and the final matter of the morning was set for 10:45. It's 10:48. Donna Carr is present. On this freezing cold morning.
And I filed an appearance in this matter by representation last time, and then I followed it up with a paper appearance after that.
Meg Bauer is here for the defendant. Samantha Sprague is here from the Can Law Firm.
And Judge Attorney Sprague and I were on the phone earlier during those Golden Pond estate cases. That's why I turned off my screen. But I don't know that we were able to finish our conversation based on Attorney Sprague's own court obligations. But I don't know if anything's changed.
If we could briefly go into a breakout room, Your Honor, I do believe that we're really close to resolution. I'd just like to speak with Attorney Bauer before agreeing to an adjournment for us to finalize those agreements.
Very good. The problem was not Ms. Carr, it was her daughter Shandy Faulkner and her boyfriend Patrick Wilsey had moved into the apartment. Adult Protective Services was called into this matter, and the Colon Police Department with Chief Brinkert also responded for alleged assault on Ms. Carr by Ms. Faulkner, and it's not good. Ms. Carr, is Ms. Faulkner out?
I have no idea where she's at, Your Honor.
But she and Mr. Wilsey are out of the
They
apartment?
are out, and they're not coming back. I've done made that clear.
Were they evicted by the sheriff or police, or did they leave voluntarily?
She left on the 19th.
With him?
Well, he left before then. But
Did she take all of her possessions?
no, I'm gonna have to,
Judge, can I
figure
jump
where,
in here?
what I'm gonna,
Your Honor, that's why we need a breakout room.
All right, I'll put you in a breakout room and I'll wait here.
Thank you, Your Honor.
Ms. Carr, just hang tight. Okay.
was she scheduled to show up too this morning?
I evicted her last time.
Oh, okay.
And Ms. Carr, don't talk to Judge about the case while Attorney Sprague and I are talking, okay?
All right, we'll just wait here. Thank you. Cynthia, I'll put you in the waiting room. These are Larkin's files. In the meantime, I will sign the consent judgment that came in Capital One versus Carol Ritchie. It was actually sitting in the fax machine. That is file number 251121GC, signed by attorney for the plaintiff and Carol Ritchie.
stuff.
Yes, sir.
It's not a prison case. I'm not going to send you to prison, but you do need to go back to jail for this.
Okay.
I'm going to put you into my community control program for a period of 5 years. That is the longest time that I can put you on community control, because the back end of this case, I just want to make sure that you're not having contact with these folks.
Sure.
I'm going to impose upon you the standard rules of community control. I want you to undergo the mental health treatment, the anger management, those 2 things. And I'm going to order that you serve 90 days in the county jail. We can break those up into 2 blocks if it makes it better for your work. I want those that 90 days done, at least the last part of it started within the next 6 months. So by the end of the summer, I want this jail underway or at least scheduled. I'm not going to impose a fine. I am going to impose the costs upon you, and I am going to remove the monitor. I don't know the ins and outs of the ICOTS transfer. That's the transfer of supervision to Indiana. I support that, and I think that's definitely, I think we have to do that. But I don't know how that works with the local jail time, so we need to figure that out with the ICOTS people. It's my understanding that we can transfer his supervision and he just come back and do the jail. I think that works.
I believe so, Your Honor.
So that would be my preference. If you don't obey the terms of the community control, then I could sentence you to up to the maximum penalty in this case, which is 36 months in prison. Anything else we need to do? Anything I forgot? Oh, and
Shall I have him just report to compliance, to probation?
yeah, I mean, I assume we don't want to start these today, right?
No, sir.
Okay, so get scheduled through probation. All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you, Mr. Haney.
Thank you, sir.
Thank you, Judge.
Oh, we'll go ahead and make him eligible for litter pickup. Mr. Haney, that means when you're doing your days in jail, you'll be eligible for the litter pickup program. So if you want to go out on the litter pickup crew, every day that you do on the crew will be an additional day of jail time credit. So
Okay.
if you do 10 days on the pickup crew, then you got 10 less days you got to serve.
Great, thank you.
All right, that's all.
If you have all
Thank
of
you,
your
Judge.
equipment, your GPS equipment.
I do.
Okay, you will need to report back down to probation. They'll remove that
Okay, I
and
already
then.
it's in the car, left it in the car.
Qualification.
So.
Yes, well, that's in the old court. Well, but I'll be somewhere.
And if the
to accomplish,
asks you a question,
and I can't accept gifts, so I accept that I'm here, people, little kids.
Judge, Ms. Sprague is just briefly communicating with her client. Ms. Carr, just,
Well,
sorry, Judge.
I put the manager in the timeout. Maybe they're on the phone. All right. Miss Carr is here with me.
So Ms. Carr, during the remainder of these proceedings, let me do the talking, obviously, unless Judge asks you a question directly. And then you and I are going to discuss a couple of things afterwards.
Yes, ma'am.
Okay.
Meg, are you going to need the breakout room for your discussions?
If if the court can spare the space and time afterwards, that would be helpful.
Yes, Laura, could you open the Zoom room, please, the conference room?
I will confess, Judge, I went back and forth on driving, and if the court was going to be closed, I figured it wasn't going to be closed until I was halfway there.
We'll make it work. We've managed to accomplish what we needed to. I don't know what's gonna happen with poor Mr. Stroop.
I don't either. Thank you, Judge. Attorney Sprague, are we ready to go or no?
We are ready, yes.
All right, Laura, I don't know if you heard me. I asked if you'd open the, oh, there it is. Thank you. All right, we return to Mr. Grove versus Donna Carr and Shandy Faulkner. Attorney Sprague and Attorney Bauer have been discussing the matter privately in a breakout space. I'll defer to you, Ms. Sprague. What's our status?
Yes, Your Honor, we do appreciate the court's time in allowing us to speak within the breakout room. We do believe that there may be the potential for a probation period to be entered in here. Plaintiffs has some concerns because to our knowledge, the individuals that we were led to believe had moved out were actually seen on the property yesterday, and a police officer had notified my property manager that Ms. Carr was not cooperating with police officers that were seeking Ms. Faulkner. And so, and they're regarding another issue, and they believe that she may have been harboring her. We are cognizant of the unique situation that Ms. Carr is in, and so we would like to provide some additional time to see if compliance can be made before we enter a formal probationary period. For that reason, we are respectfully requesting at least a 10-day adjournment, during which time we will get the writ over to your to the court today and make attempts to get that writ executed and ensure that Ms. Carr is complying with the removal of Ms. Faulkner and continued absence of her before we put a formal probation period in place.
All right, I received a date stamped today, a report from Chief Brinkert, the Colon Chief of Police, who's been there for a long time. He was there yesterday, January 22nd, and from the report, it's in his opinion, Ms. Carr was assaulted by Shandy Faulkner and had some serious concerns about that. And Adult Protective Services was contacted. And there had been some allegation that she was there yesterday.
Judge, was this report provided to you by the officer sua sponte or by Attorney Sprague or some other way?
I think it was provided by Adult Protective Services. There's also an adult PS file. I don't know. It just showed up and it was handed to me.
Okay.
Ms. Sprague, do you have it?
I don't have a copy of it, Your Honor. We were going. I was just made
to
aware of the
both
police
counsel.
officer's presence during the breakout.
And Attorney Sprague and I have a good professional relationship, I think. So I trusted that it wasn't from her, but just kind of curious where it came from.
All right, Ms. Carr, the bottom line is Ms. Faulkner and Mr. Wiltie need to be out of there. If they have some concern that they're coercing their way in there and frightening you, you're gonna get evicted, you're gonna be homeless.
She has threatened to break the patio door glass if I didn't let her in. So I'm not letting her in, and if she does that, I'll just call the police.
All right, well, we're gonna adjourn this 10 days. Let's see what we got here. And I don't want anything to happen to you.
And Your Honor, if I may,
Yes.
I know Ms. Bauer has probably already coached her or provided this information, but when a police officer is at the door, if there are individuals within the home that may cause an assault, that is a perfect time, in my opinion, to present that to the police officer so that way they can clear your home and you can maintain a safe environment. And so I'm not sure if that's what happened, but we would just like to reiterate our encouragement of that, management's encouragement for her to conduct that.
All right, 10 days from today would be February the 2nd. Let me see what that Friday looks like to see if you guys are scheduled to be here for anything else. Probably not, but let's take a look.
And Attorney Sprague, I didn't ask you about this when we were discussing, but I don't know that we ever got a copy of the default judgment.
The default?
That entered at the first hearing against.
I can provide a copy today. I don't know if it was, I don't know if, I know it was uploaded on my file, so I'm not sure if it was also sent to your office. I'll confirm.
Have my file in this district.
Oh, then let me see where we
Yeah, I
submitted
have
it
a
then.
copy dated default as to all occupants other than Donna Carr.
Okay.
So that writ needs to be served on her. February 2nd is a Monday.
And that
And I
writ
don't
would be
see,
effective
Ms.
immediately.
Sprague, that you're set to be here at any other time. So how about if we go to 2:45 on February 2nd?
February 2nd, 2:45. That would be perfect. Thank you, Your Honor.
All right, Ms. Carr, I'm gonna ask you to go into the conference room.
Okay.
And I'll let you speak privately with Ms. Bauer and you can discuss your options here. Cynthia, you're on top of what's going on there on the ground. Certainly if she's seen there, she's subject to being evicted and she's a trespasser. And if she is in fact committing assault, there may be other criminal ramifications to this. But for now, we'll continue this to February 2nd at 2:45 p.m. And I will see that both attorneys get a copy of this, the police report.
Thank you. And Ms. Bauer, I just forwarded that initial judgment over to you as well. And then we'll be in communication regarding the execution threat.
I appreciate that. And Judge, do you have the writ in front of you? And
I have to submit it.
Has to be
I
submitted.
do.
Oh, did we submit it already?
The writ was
The 19th, I believe.
Yeah.
19th, yes. I wrote,
Okay.
yeah.
We'll get that over.
January 19th, that date is passed.
Judge, my understanding is that there will be a writ forthcoming, hopefully today. If Your Honor is still in the courtroom or in the courthouse.
Yes, I certainly would sign it. We don't have a writ. So yeah, when it gets the writ, plaintiff will submit writ.
Okay. Thank you, Attorney Sprague.
All right. Thank you, Your Honor. Thank you, Ms. Bauer.
All right. All right, thank you.
Ms. Carr, you know that room that we were in last time? You want to go on the first one? Is she still? there,
She's
Judge?
gone.
She's gone. Okay, good.
All right, Cynthia, I'll remove you. I will open the breakout room. I'll put McBauer. You should be able to just, oh, I gotta bring the Zoom room in.
And yeah, I got it on my end. I do appreciate the court's assistance in facilitating this.
All right, someone's gonna need to turn on the camera and the mic in there, but you should be good to go. All right, someone may need to assist Miss Carr in there to join the breakout, but I'm gonna suspend the live feed and the record. I have a hearing at 2 o'clock and some other matters to address. All right, that was a vigorous morning, we'll call it. And I have a vigorous afternoon. And a messy office. I don't like a messy office. All right, thank you for joining us this morning. We'll be back at 2 o'clock with further Colon Township versus Yoder proceedings.
He was unavailable.
I've ordered them. Here's, see if we got a file. Is he out is he in custody or out? All right. Call, we asked the bailiff to call into the hall Floyd Brooks. There is no answer here in the courtroom. Let's review. What is how are we doing?
The only thing is what is the substance abuse.
What about it? That's kind of important, substance abuse.
He's using. And they built class. He's out there.
Ma'am,
He was sitting out there.
he's not there now. There is no answer. Floyd Brooks? Floyd? There is no answer to that name called into the hall. No answer to the name called here into the courtroom. So we're getting positives?
Yes.
Get a motion to revoke probation. We're not going to tolerate it. My goodness. What's he testing positive for?
Cocaine.
Cocaine. It's only the felony every time he does it. On my watch. All right, can you get that as soon as possible, the memo, so we can get it?
Okay.
And as far as he is concerned, he is did not appear. A warrant shall be issued for his arrest, no bond. At this time. Here is Mr. Kimmer. Lisa Carmen.
Sure. When she's present, I have one last setting. I've spoken with the prosecutors.
Kind of hoping we'd move this one today. It says plea, but
Your Honor, we should be able to work something out. And it's a minor.
I'm sorry, say that again.
We should be able to work something out. I've spoken with Mike this morning with the prosecutor. I just need one more setting, sir.
This was a motion to revoke probation out there, right?
Yes, sir.
Well, we don't need an agreement. Really, do we? When can we do that? If I gave you some time.
Next time. Couple of weeks. Couple of weeks.
That's all.
That's all.
All right, let me ask you, hold on, let me look and see if we got a fire we're having at 5. Yeah, everybody says that, but we had one on the last case.
I think so.
Ms. Carmen,
Yeah.
there's a motion to revoke probation. You're on probation for aggravated robbery and alleges that you committed an offense over 2 years ago.
Yeah. Well,
There was a good reason, I guess, that one stalled, huh? Because this was filed just in August of last year. But this states this occurred almost 2 years before that. What took so long?
Well, the offense was committed on December 16th of 23.
23.
They got indicted on September 24.
I know, but this didn't get filed until August of 25.
Yeah.
Just one of those that went slipped through the cracks, Judge.
Okay.
When he got caught, we got it. We got
Okay.
it followed.
I know, we got,
Actually,
that's
goes back-
what happens when we're the 22nd largest county with the 16th highest crime rate. We're fighting fires everywhere.
this went back to 2016.
Mhm.
No, yeah, she's been on probation since
Yeah.
2016, but
Yes. But we should, Your Honor, we should be able.
here's what's going to happen. I'm going to reset this for 2 weeks. Either there's an agreement or we have a hearing. I'll make the decision, okay?
That's
All
right.
right, we got, because those things
Thank you, Chair.
way too long. Okay, thank you.
Yeah.
Yes, sir.
Represented by Mr. Kidd, we have Mr. Harrison, the prosecutor's office. Sir Bridgman from probation. We are here today for a hearing on ILC, but it's my understanding we're withdrawing the motion for ILC. We're going to go forward with sentence today.
We are, Your Honor.
All right. Mr. Tyree, how old are you?
I'm 33.
How far did you go in school?
All the way to the 12th grade.
Were you able to read and write English?
Yes, yes.
Are you under the influence of drugs or alcohol
Am I under? No.
right now?
No, sir.
Are you taking any medications?
Yes.
What are you taking?
I'm on Sublocade.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes.
You enter our plea of guilty to this charge. We're going to go forward with sentence today. I'm going to put you on probation, and essentially the plan is to keep doing what we're doing.
Yes,
Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Kidd before you signed it?
Yes.
Are you satisfied with the representation that you've received in the case?
Yes.
You're going to enter a plea of guilty to 1 count of possession of cocaine, 1 count of aggravated possession of drugs. These are each 5th-degree felonies, punishable by up to 12 months in prison and a $2,500 fine. If you violate the terms of your supervision and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Your rights really haven't changed that much since we went over them back in 2021. Still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to counts 1 and 2, that on or about June 7th of 2025 in the city of Springboro, Warren County, Ohio, John Tyree possessed cocaine as well as methamphetamine that was lab confirmed, cocaine at 0.234 grams and methamphetamine at 0.494 grams.
Anything on those facts, Mr. Kidd?
Nothing, Your Honor.
Mr. Tyree, did you hear those facts?
Yes.
Do you admit that they are true?
Yes, Your Honor.
Do you understand the rights you're giving up by entering your plea?
Yes, Your Honor.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to treat the ILC report as a PSI and go forward with sentence today?
No, Your Honor.
We're satisfied with that, Your Honor.
All right, we have 3 days of jail time credit and no restitution, right?
Correct.
Mr. Harris, anything from the state?
Nothing further, Your Honor.
Officer Bridgman? Mr. Kidd?
Mr. Tyree is looking forward to the opportunity of showing you that he can do well on probation. He hopes to obtain another job once he's out of Genesis. He is appreciating the period of sobriety that he has, and he wants to continue that.
What do you want to tell me, Mr. Tyree, if anything?
Yes, Your Honor. You know, I had been working. I was assistant manager, training to become the GM at my job. I was paying bills. I stayed sober for 2 years. And I started overworking myself, working like 80 hours a week, and I got stressed out and I relapsed, causing these new charges, you know, and it comes with a lot of shame and guilt because I don't have my parents anymore, and it's just been hard. But, yeah, sorry. I put you through hell last time, and I want to show I can, you know, do the right thing this time.
It was a lot of work last time, Mr. Tyree. I'm hoping we can do
I know.
a little better this time.
I know, sir.
I'm going to put you into my community control program for a period of 3 years on basic probation. I'm going to impose upon you the standard rules of probation, delegate to your officer the ability to make special or additional conditions as they see fit. At this point, it's going to be a special term of your probation that you enter into. Successfully complete the Genesis program plus any aftercare. I'm not going to impose a fine. I am going to impose the costs. We have 3 days of jail time credit. If you violate the terms of your supervision, I can impose up to the maximum penalty in this case, which is 12 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you.
Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Next is the case of the State of Ohio versus Justin McIntosh. That's right. Wait. Did we call for him?
Rodney Cleveland. Uh-oh, there's a big sigh. There's a big sigh. He came in to sign. Brett was signed. That's not good. Taking a big breath. You were Rodney Cleveland? No, where's Mr.
He's in custody.
There's Mr. Cleveland.
Very different ethics.
Your Honor, on this one, we are still waiting on the new drug case. I'm not sure what's taking the lab so long. We have checked on it multiple times.
You talking about this February 6th of a year ago?
Yeah,
Thank you.
I'll email it to you if you want to get her.
it's my understanding that it's still coming according to the people that I've checked in with. I just don't know why it's taking so long.
Where's the problem? Because this is abnormal, and there he is sitting around languishing. He's in the twilight zone. We got to move forward one way or the other. I mean, this thing was filed in May, and we still don't have.
I believe we're waiting on the labs for the drugs. I'm not.
Can you find out for sure? It's kind of important because if there's a delay, I'd like to know from the lab why. Because it.
This is the case of the state of Ohio versus Justin McIntosh, 24 CR 41574. Present before the court is Mr. McIntosh, represented by Mr. Swift. We have Ms. Trainer from the prosecutor's office, Officer Bridgman from probation, and Ms. Wilkerson from case management. We're here today for a hearing on the motion for intervention in lieu of conviction. Mr. McIntosh, your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge. But instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. You're going to follow the rules. You're going to engage in some sort of either drug treatment or cognitive intervention, something along those lines. You're going to pay the restitution, and you're going to refrain from the use of drugs or alcohol during the treatment period. If you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I'm going to revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes, sir.
How old are you?
22.
How far did you go in school?
I graduated high school.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Albuterol for my asthma.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what I just told you, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. Looks like on the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Swift before you signed it?
Yes.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of receiving stolen property. It's a fourth-degree felony, punishable by up to 18 months in prison and a $5,000 fine. If I were to send you to prison because you violate the terms of your ILC, and I'm not saying that you're going to, but if you did, and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what what you want to do?
Yes, sir.
Ms. Trainer?
Your Honor, on or about the 5th day of February 2024 in Warren County, state of Ohio, Justin McIntosh did receive, retain, or dispose of the property of another, knowing or having reasonable cause to believe it was obtained through a theft offense. The property involved was a motor vehicle.
Anything on those facts, Mr. Swift?
Nothing.
Mr. McIntosh, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the right you're giving up by entering plea?
Yes, sir.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction, stay these proceedings for a period of 3 years. We're going to adopt a treatment plan. You were gone for a while in the case, and during that time, though, you did everything that I probably would have asked you to do if we would have gone forward in 2024. So we have to figure out what that's going to look like. I'm confident that we're going to be able to put together a treatment plan. I'm going to release you from jail today. What's our jail days? 115 days of jail time credit. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. It's going to include random drug testing. We have restitution in the amount of $969.09, which I want paid within 6 months or get ready to go back to jail.
Okay.
Anything else? All right. Good luck to you, Mr. McIntosh.
Thank you, sir.
This is too long.
Okay. I can speak to the lab. I know they move
They
it.
got a lot.
Yeah.
But motions to revoke, we're in the twilight zone. Those are important.
Turn over at the lab to Judge, so train new people.
How long have you been in custody?
Judge, if possible, while we're trying to wait to get the labs back, is it possible to set a bond for Mr.
I'm not going to do that with what's is alleged here.
I'm sorry?
How am I going to do that with? what's
Well, in the
alleged
new
here?
cases, it's been over 90 days and they haven't indicted, so they're not ready on those. And then on the latter part, this is, if my memory concern is.
This is what happens.
This is a deferred.
They're going to ask, and the court's got to consider whether he should be now released. And we know what is happening. He's
got a job waiting for him, Judge. He will be in attendance.
He's alleged to be using synthetic marijuana. That's straight from hell. We all know that. Methamphetamines. Failing to provide verification of completing anger management that he was supposed to. Not doing community service. I mean, goes on. There is something I am curious about. Allegations 2 and 3 allege the exact same things. How can that be? What's
Your Honor, I believe that it's.
what's the distinction between those two? They're both, he admitted to using illegal drugs, synthetic marijuana to the police, and then illegally possessed synthetic marijuana on February 6th. Y'all carved out 2 allegations. What's this? Difference between?
I believe it's because of the use and the possession, Your Honor.
But
Condition 10 of this probation was do not use or possess. And according to this, he used and possessed.
It's alleging word for word almost the same thing. I was just trying to figure out what you're calling out of those. In both of those state, he possessed synthetic used and then possessed on the same day in violation of the same condition of action. Here's the issue is you have in we're waiting on the drugs, but also there's an allegation he admitted to the police that to the Port Arthur police that he was using illegally synthetic marijuana. Let's just go on that.
Well, Judge,
what?
I'm going to have to object to going on that one because that would be part of any discovery on a new case. The state has not provided me any sort of anything to indicate that there was in fact a valid admission for this. This is simply someone pleading that he said he admitted to it. And I don't know that anyone in this courtroom can verify or testify to the fact that he said anything.
Well, can we?
That would be part of the new case. We don't have the new case.
I'm going to set this for a hearing on 2 weeks. Okay. and get him whatever discovery we need. And if we can't get the results, we'll go on what we can, because this is language too long.
Can we have a bond in the middle?
No.
Judge?
No, sir. Willie Coward.
Morning, Your Honor.
What is this one? We had, I guess, a hearing. 18-30013 is called your Willie Coward.
Yes.
All right. And the state and the defense are both here. There was a motion to revoke probation that had been filed back in 23. The defendant pleaded true in June of 25, 2 violations, which were not substantive, but were failing to report properly to the probation office. So we continued him on probation. Here's a review. And from probation, how are we doing?
Your Honor, after the last court appearance, you had advised Mr. Coward to, if at all possible, to pay the restitution in full. And Mr. Coward did do that.
How much is that?
He paid $3,569.12, which finished paying the restitution in full. The case
Tepe is a lark.
Yes.
The case was originally set for May, and so I sent a memo to you advising that the restitution had been paid. He is continuing to report monthly to Ms. Young. He does reside in Vidor with his brother and sister-in-law. At that time of the last court date, you had advised that you would be willing to consider other, a lesser restrictive community supervision.
What else do we need to accomplish on probation?
Mr. Coward.
Because he's on, just not to interrupt you, but just for the record, he's been on probation now for over 6 years.
Mhm.
And if they do well, of course, we can shorten probation. And that's my question. Is he worthy at this time?
The majority of Mr. Coward's time on probation, he has been incarcerated within TDCJ. Mr. Coward.
Did he successfully complete that incarceration without
Yes, sir.
parole revocation or anything?
He was paroled and that was revoked.
Okay, while he was on this,
Yes, sir.
okay. But he has been paid that price that was assessed in
Yes,
that particular case. On this one, what other conditions is the probation office is the probation office stating needs to be accomplished?
The only concern that we have is Mr. Coward does have some medical conditions. As of recent, as of January the 6th, he did submit a drug test that was positive for his prescriptions as well as methadone. That's the only issue that I see at this point in time. We are prepared to, if you allow him to go on to an inactive probation, we can, we have an order of allowing that with some additional conditions such as reporting for random drug testing when requested, even though he is on inactive probation.
The drugs that he's testing positive for, those were not the prescribed drugs?
Not methadone, Your Honor.
No. What happened there?
Well, so, I went to work with my sister and didn't have my medicines. And you get real sick on the medicine, and if you don't take it, and methadone is the only thing that gives you any relief.
So you self-medicated?
Yes, sir.
Your Honor, that was the same story.
That's not the way to do it on probation.
That was the same story that he offered me in September of 2025 when he tested positive for methadone as well. That was addressed at that time, and we completed a substance abuse evaluation that recommended special needs safe P. But because of Mr. Coward, he's a registered sex offender, he's ineligible for safe P placement.
All right. Shame on you the first time. Shame on me the second time.
Yes.
If I just say, we went over this and you know that you touch the stove and it burns, why would you embrace the stove now?
Your Honor, because I thought we were talking about the first time, but I didn't know the second time. I was unaware that I tested positive the second time.
Well, you tested positive, but you would be the best person to know whether you used improperly or not. But the tests, we're going to rely on the tests unless somebody can prove that they were not administered in a correct fashion. The tests are scientific.
I've read that the Texas rule, they give false positives on something.
We're going to rely on the tests.
Yes.
By the preponderance of the evidence or greater.
Yes.
What are you suggesting, Ms. Stan?
Your Honor, I would offer the court two options. If you wish to dismiss the motion and continue him on probation, under a direct supervision, I would ask that you consider allowing him to report and ordering him to report directly to Jefferson County because of the fact he does reside in Orange County. We would even be willing to reduce his supervision fees half to $30, or you can place him on inactive. And if you'd like to review the inactive order that we prepared, if that would be substantial.
What do you think is in the best interest of success in this case? You're closer to him. I mean, those are, to me, that's 6 of one, half a dozen of another. I don't know how to weigh those, and I trust you.
Your Honor, Mr. Short did come through with what you asked him to do, with the exception of the recent methadone positive. He reports as he's directed, even though he's tardy at times, but Ms. Lakin Young is now supervising him and she's working with him. He would be transferred to a different officer with a direct report here. I would say that having him report to Orange County would be a hindrance on him financially as well as transportation. And that would be, I think, a path for unsuccessful probation.
Okay. If we continued him here, what conditions would you add, if any?
I wouldn't add any additional conditions, Your Honor. At this time,
I'm just concerned about that, the methadone.
yes, sir.
Positive.
That's the concern because of the fact that I specifically addressed it with him on the first one.
Okay, before I do something, go ahead, Mr. Turk.
Judge, the goalpost keeps changing on this one for us.
The goalpost changed because of him.
No, sir, not on this.
It was the methadone positive that's changed.
I understand, Jeff, but just a couple of days ago, I got the recommendation from the probation office that they were going to recommend inactive. Now it's going to, hey, they're coming back and say, these are the test positives. Nowhere in this email, nowhere in these conversations where he's put in there. Couple with the fact that.
Guess what? They're allowed to change their thoughts.
I understand that.
Okay.
I understand that.
They're not making contracts. He made the contracts. He made the contract with me that we violated. So don't blame them.
I'm not blaming them. I'm just.
But don't criticize them under these circumstances, please. Just what's in his best interest so he can be a successful person and be productive in life and be independent.
I think at this point, Judge, he's complied with most everything that everyone's asked of him.
Most everything. It's not almost there. Doesn't get you the participation trophy. I want the winning trophy for all this. Okay. What else do you want? Go ahead.
I had come into the impression that this was going to be recommended inactive probation.
Sorry about the frustration, but I'm not going to criticize these people. They produce a result that is unheard of in probations, and that's 93% success rate, which we're all proud of, and we want him to bring the bar up to 94 with his success. So they're not going to get criticized on my watch. They're working hard, and they don't mistreat people. We try to even drag them across the goal line if we have to, if that's what is necessary. but I want him to be independent, to make his own right choices independently. Here's what I'm gonna do. Okay. We're gonna, I like your idea. And what we're gonna do is we're gonna continue your probation and we're gonna do it that is cost effective for you. I want to review in 3 months for the termination of probation or not. Okay?
Yes.
And you do well, all things considered, and probation says you're doing fine, and then that's what I intend to do.
Yes.
So, but let's get
Yes.
another 3 months. Also, do whatever it takes so that it's cost effective for him. So it's less costly and he doesn't have to make those drives.
Yes, sir. I have an order.
Oh, sorry, excuse me.
Sorry.
Supervisory fees are going to be reduced $30 per month. And you're ordered to report to the probation officer in Jefferson County. We will review in 90 days or less. If you feel like we don't need to wait 90 days, let's get him free.
Yeah.
I think you're doing good.
Thank you.
But once again, yes, we want you to be on this 93% success rate, not the 7%.
Yes.
Because I know, I believe you're able to, and that's, some people are hopeless sometimes. You just know it's frustrating that they're not going to make it. You are the ones. Just make the right choices. You know what they are. That 3 looks like a 5. Here is something. Bring it back to probation. If you can, let's get a resetting for 3 months, please.
Thank you, Your Honor.
Thank you.
Your Honor. Judge.
Yeah.
Peggy said to tell you that she's working on the staff.
Hold on.
Thank you.
Yes, ma'am.
Yeah, they're supposed to be bringing a restitution payment as we speak.
On which one?
Oh, Tremba. If you only need to, but otherwise, no. Hey.
Okay,
He's in custody.
Tremba, do we need him out?
Not right now. I'm waiting to see. They called me and said that they're trying to pay probation and they're supposed to be coming in to see it.
Well, that hurts, whatever that was.
So if you get, I can hold that for a few more minutes, then see if they can get here.
Teresa Hammonds, John. Okay, this is 097349. And the defendant is present with her attorney, Mr. West. There was a motion to revoke probation that was filed long ago. And it is all about monies. And there was 6 figures owed here that we've been working on since 2020. And here we are 5 years later. Where are we? On things.
She's paying $502 a month.
That comes out $6,000 a year or so.
Her initial restitution amount was $125,000. She's paid $53,776.
Yeah, grand. How much of that is restitution?
That is a restitution.
That is it.
Yes,
We're
sir.
all talking about everything else is frozen.
Yes, sir.
Yes.
It's not an active
Yeah, she's on an active probation. She's, only thing she's doing is just paying restitution, Your Honor.
Okay, how's that working? Well, the quicker you pay, the quicker
Yes, sir.
this case will be terminated. And is that, well, it's up to you. Are you able to pay more to get this off quicker or not?
She, in the past, Your Honor, has paid more when she could. This past year, she's had a bunch of financial issues, but she's been making the payments she needed.
Your
to make.
attorney's not sticking it to you on the fees or anything.
No,
No, he's very fair.
No.
He's a very fair.
no, she's been like in the past. She is when she's been able to pay more. She's paid more. And this, she told me outside she was worried about that because she hasn't been able to pay more like she had been in the past. But she's had a bunch of problems and issues. But she's been on target. She just hasn't been above and beyond like she likes to be. So
Okay. What is the balance you said?
The balance remaining is $71,224.
That's the balance that we still owe here, 70,000.
71,
And we're making how much a month?
502.
Mhm. Y'all know that's a lot of time. 11
good at
years.
math. So I'm not good at math. I usually not.
That's 11 or 12 years.
Yeah. Like that, she's been trying to make extra when she can. In the past, she
I
hasn't.
should live so long. But I'm going to tell you this, I hope to see you make that last payment. I want to be able to see that and celebrate with everybody.
Yeah.
We should live so long, but the rule of law is you pay what you can. And, but the quicker it's paid, the
better everybody is.
quicker everything ends. So we move on without this having to be thought about. Okay, what do we do? Review in 6 months again?
That's what we've been doing, Your Honor.
Probation, anything else?
Sir.
Anything from probation?
That's just, other issues except for the money.
Yeah. Okay, please get a resetting. Thank you. Catherine Furlow? Yes. Catherine Furlow?
Yeah. Yeah, it's natural.
Wow. Is in 21-38340, we call Catherine Furlow. There is no answer in the courtroom. I'm asking the bailiff to call into the hall for Catherine Furlow.
No response, Judge.
No response. Are there any issues on this, right?
In Harris County feel like that she's doing best she can at the moment. She doesn't have a job or anything like that right now.
Why not? Do you know why?
I don't know.
Is she physically unable to work?
But she's not. From what she's telling me, though, she said that she's been applying for jobs and whatnot, but haven't, due to her background, nobody is giving her an opportunity. Yeah.
Well, it's not theft related, or embezzling. It's an accident. But she's not getting jobs because of that.
That's what she said. And I think what the majority of the problem is that she's looking for employment in the medical field.
And she's on deferred too, so she's not convicted. And this, I don't know how that would deter her. Unless there's just a rule you can't be accepted into the medical field because you are on a form of probation or community supervision, but it has nothing to do with theft or fraud. Those are kinds of things that I can understand employers would have concerns with. I know employers sometimes have an accident on the way to work. Yeah, and they're at fault. I don't think they just resign. In all fairness, but The other thing is, well, she live in Houston.
Yes.
The ice hadn't hit Houston yet, has it?
Not yet.
Wow.
Not yet. She said she was having some car problems.
Okay. What do you, she's not here, but what would you suggest? Is there anything we need to do differently other than just touch base with her?
That's it.
Okay. She's been on probation for a while. What is it she needs to do to discontinue this? Because many times we reduce it to a third, which I guess she would be eligible for under in this case, but
she has a lot of restitution that needs to be taken care of. A lot of restitution.
How much are we talking about?
145.
Yeah, about.
Okay. How much is she paying a month on it?
So due to being unemployed, she hadn't been able to make any payments. She made one payment in 2025. Yeah. Definitely, I discussed that with her as well. And, she just started going on and on about the hardship and things that she was having over the past year.
Well, we're all in that same boat.
Absolutely.
Every one of us have our own special circumstances of hardship. But she has an obligation under law that needs to, and a victim that has to get paid back to purge this problem. What does state say about this? Number one, I don't know why she's not here, except I don't think there's a problem on the roadways yet.
Probably with a vehicle, Judge.
If she isn't able
What
to
do we
afford
do today if
restitution.
she doesn't show up?
She's doing well otherwise. Everything else we're paying.
How much has she paid in the last year? Restitution, please.
It's about
When's the last time we read
$100.
$200.
$200.
That's not enough. Be 50 years at this rate.
I mean, really, we can't.
She needs to be here so that we can talk to her about it in person. And I'm going to ask the probation office to get something from her why she didn't show up, but then we're going to have to just we'll reset it a week, but that's it. Because we need to deal with this, her face to face. Anything else to add on this? It's frustrating, and everybody's got to show up before we can really do something. But I'm real concerned about this lack of any income. This situation does not deter most people who are on deferred or unadjudicated probation from getting jobs and taking care of their payments. And I need to know if she's what the probation office and the state feels as though is being done in good faith on her part to pay the victim back for the mess that she was the cause of. What was the original restitution amount?
$44,516.
How much did she pay in 3 years?
So a total of 350.
I'm sorry, 4 years. Because she's on January 22, 22, 23, 24, 25. That's 4 years. And it was January 5th, so it's over 4 years.
Here's a copy of that.
How much?
But she's made a payment of it's roughly about 350, maybe a little bit more, but definitely not $400.
About $400?
Definitely not that. $400 be pushing. We need a calculator.
Yeah, it shows about 385 of total credit she's got for it.
I think a period of time that she was
It's
incorporated
about
also.
$8 or $9 a month.
She was incarcerated in the county jail for a period of time as well.
But couldn't have been
time.
Well, you know, you gave her 60 days up front back in 2023.
Matter.
Yeah.
Yeah, that's insignificant on this. No. But otherwise, she's healthy and able to work. So, okay, well. I'm gonna reset this 1 week, order for her to be here. But I'm concerned about this. This is unusually poor performance for restitution on a case
It's fine.
that is
That's going to be okay. Because she's a
third-degree felony of accident involving injury. Oh, she hit a guy on a bicycle. She ran over the guy on a bicycle.
Yes, sir. I remember
That's
that
right.
case very well.
Okay.
Can the probation office get with the victim also and give me the status of what the victim's status is physically? And
Because he did walk away from the accident. He had some injuries that, but he was not.
I want to make sure
He
he
has had some surgery, I think, on his.
it's been a while now. I'm just curious if he's gotten any,
He's gotten.
what his status is from this event.
That's what she was also supposed to check, I think, last time to see if there was what insurance or what her insurance paid out and bring proof of that.
Not actually after about.
I know. I haven't seen anything yet.
Yeah, those are too many uncertainties. We need to resolve that in person. Thank you. Gary Metz, please. 16-24069 is now called to Gary Metz.
Yes, sir.
You are here on, let's see. Probation review. And Mr. Menard has been your probation officer all the time?
Was Miss Segrist and Martin County now.
Okay, now you're here with us. You're still in Silsbee, live in Silsbee? What's your address now? You've updated the address. Do you live in Jefferson County?
Orange County.
You're moving around Southeast Texas, huh? All right. This is an update on a status here. You've been on probation since 2016, 10 years deferred or unadjudicated probation. You know, for family assault. And how do you think you're doing? Fine?
Besides the money, yes, sir.
Okay. And
yes, sir. He's doing fine. He's done everything he needs to do. The only thing was the money. He was planning to use his retirement he's going to pull from his retirement to make a big payment to get everything paid off, but he got laid off. So when he got laid off, he had to use that money to, make ends meet until he got a new job.
No other necessity.
Yes, sir. So whenever he gets
What's that plan now?
whenever he gets his taxes, he's going to pay off the rest of his fees. And he gets off in March.
What do you mean?
His probation will be done with on March 27th.
That's the anniversary. But if he hadn't done it, what do we have? If he hadn't paid it, what do we do? We have to file a motion.
We'll have
right?
to file a motion if he doesn't pay it.
To preserve it, a toll. Are you gonna be able to take care of that?
It'll be done. It'll be done. It's
Okay.
accepted. I'm just waiting.
Because if you don't, we have to file a motion to revoke probation, and then then you get processed through, which is a pain.
Yes, sir.
And
It'll be
but
done.
how much what is the amount that he needs to pay so he knows?
Well, his current balance needs to be adjusted because he's placed on inactive. So we have to go back and adjust the fees. So we don't have a current
Downward.
Yes, sir. Because right now it's $4,910.
So it's going to be less than that.
Yes, sir. It will be.
All right, good. So the anniversary is on March 28th. And so what, 4 weeks?
Yes, sir.
You think? Is there also great news?
Yes, sir.
All right, let's reset it for review in 4 weeks. Okay. Yes, sir. All right. Mr. Metz, on this other, this underlying offense, how's the situation with your family?
Everything's good.
Good. That's important.
Yes.
Cynthia Mosley?
Thank you.
Miss Mosley? Oh, boy. Here we come. Here we go. Cause number. 18-30059 is called Cynthia Ann Mosley. That's you?
Yes, sir.
Okay, there's a review we're doing that we have regularly. You have been on probation for a while now on theft. There was a lot of restitution, I think 11,300 at the beginning. Is this all about restitution?
Yes, sir.
Okay, it's restitution day. So where are we on all of this? What?
Been making payments as we came up with, and she has a balance of $1,316 that's left.
That's getting low. Good. When can that get paid back? You know, all things being the same, if she was able to get that money tomorrow, would that case then be terminated?
Yes, sir. That's the only thing that's really.
It's the only thing is on deferred probation or unadjudicated probation.
Yes.
So, we're getting close. So what do you think? How long before we can get that paid?
I'm trying.
You're trying, how much are you able to pay a month?
280.
280. And it's how much is left?
1,316.
Okay. Well, that's about 4 months to go. So let's review it in 90 days and see where she is. Okay. Is that good? Otherwise, okay. And if you pay it earlier, let me know and then we can terminate this thing. Okay. Thank you.
Judge, I'm showing, hang on. I'm showing that we extended her probation 2 years back in 24. So I think that.
I don't have that on here.
Well, I'm just showing
cover. So yeah, that's.
Y'all can correct, because I'm only looking at this digitally, but I think that she may be at an expiration date before the 90 days is what we're getting to.
May 5th is her expiration date.
Okay, never mind. Sorry.
Are we okay?
Yes, sir.
We have till May, Judge. That'll be within the 90 days.
March 10th, is that good?
February, March, April. Yeah,
Want me to get that? Oh, sure.
end of April.
Yes, yes, you can.
Rebecca McWhorter.
She's probably doing it.
I've received something from the probation office, which is good news. So on this,
Okay.
13-17599 is called Rebecca Johnson McWhorter. That is she. Mr. Rennick is here representing you. And you have been on probation since 2013. for the state jail felony of theft. You were placed on deferred or unadjudicated probation for 10 years. It was just a lot of restitution, over $80,000. Where are we on all of that after a decade and 2 or 3 years? After 12 years? What's our, is it all about money?
Yes, sir.
And what's the balance then?
Right now, the balance is $36,411.
A little over 36,000?
Yes, sir.
Okay. And how much is the defendant making a month to pay?
She hasn't made any payments recently
Why not?
because she's currently going through a divorce. And after the divorce, she's going to take the settlement from the divorce and make a big payment to us.
But that's just talk, right?
Yes, sir.
Oh, and,
She's going to make some payments. Then.
what are you saying you were promising to do? So we can all have it on the record so that there's not a doubt about it later.
I wanted to make payments monthly, but I've been having a problem keeping the lights on.
Yes, ma'am.
Dealing with everyday issues, and
Okay.
my husband is fighting the divorce, and he stopped paying for anything, including his spousal support.
He was ordered to pay support and he's not doing. Is that being resolved? Do you have an attorney in that one?
Yeah, we were supposed to go to court on Wednesday, and it got postponed because my attorney had to be in a CPS case somewhere else. So
It's not Mr. Rennick, is it?
No.
Yeah, it's
Mr. Rennick is a new family.
It's actually Glenn Crocker. And
That's okay.
yeah,
You can't be two places at once.
yeah, and I understood that, but it just put me,
Frustrating.
yeah, put me in bad. This is like the 10th time it's gotten
Okay,
postponed.
what's our plan today?
The plan's for her to start making small payments every month, whatever she can make payments with.
When is it expected that the termination of the marriage and all will be resolved?
I contacted Mr. Crocker's office, and they told me they would email me a date, and it's been every 6 weeks before we could get into the court.
Okay.
We went in December 3rd, and the judge and the lawyer said it was going to be an all-day thing. Because he wants to argue about weed eaters. I just want to get it over with so that.
I'll bet you do. Yes. So what do we want to do on this case today? Reset for how long? We'll review.
What do you think? Next court case.
I would think at least from what she's been keeping me updated on the family situation because she thought resolution.
Is 90 days good?
I think that would be fair.
3 months? All right, let's reset this for 3 months and see. Hopefully we'll be good news to finish this so you can move on with your life, and good luck. Good luck, man.
Thank you.
Yes, sir. Thank you.
Yeah.
Okay, I've got Edward Tremba. This is a sentencing.
Sort of, Judge, he was able to pay $1,000 this morning towards his restitution. So with that in mind, they indicated that may be able to pay more if given time to do so. And I'm waiting for him to come up here.
He's in jail.
He's in jail. He's in the tree. So this is the receipt from this morning.
That was today.
Yeah. A little over half of what he actually owes, I think.
All right, we now call 15-21847 State of Texas versus Edward Tremba, present with his attorney, Mr. Turkin, state's attorney. Earlier in December, the defendant pleaded true to failing to report to the probation office and as directed, and he had been out for a while, I guess, and we finally caught up with him. He pleaded true and to this motion to revoke probation, which alleges that the defendant has been on probation for forgery for 9 years, going on 10 years. and failed to report back in 2016. And I guess he had been absconding. We had lost the track of him.
Yes, sir.
Stand by. I'm on warrant duty.
Thank you.
Good night, Judge.
Debate.
Says that he cannot be around the victim, which is his son. It just wasn't the intention of the parties that day. It was never brought up.
Is that what the state says?
Never.
Yes, sir. And I reached out to the son's mom.
The state doesn't have an objection to
No
this
objection.
request? Well, do we have to have him here?
I don't believe so.
I don't think so.
Well, let's do something to modify the term of probation if everybody's agreeable.
Yes, sir. I'm fine.
And I'll sign it.
That's it. There should be an order, I believe.
Get a probation amendment, that way the paperwork.
Okay.
All right, come in, let's see, move it into this, okay, this states the order that's been proposed to the court orders removal of the condition of probation that does not allow DeMarcus Anthony Jones to have contact with the complainant in this case. Is that good for the state?
Yes, sir.
And is from probation, can I sign this? And then you have something, though, a modification I've got to sign.
Yes.
All right, so I will on this date then.
It allows him to be around.
So January 23rd, this motion is granted. And I'm changing this to 26, not 25. You got to change your settings.
You left a 5 on there?
Well, I think you filed it, to be fair.
Yeah, you probably are right. Yeah.
Yeah, you.
Send them a reminder just.
Well, maybe. Yeah, that's for 19.
Stay watching graph 6.
Okay, here it is.
That's all I have on that.
Well, we're going to assess on that. Just a second, Dustin. I need to talk to you about something.
Okay.
And then we have Mr. Walker.
Judge, Mr. Kelly, he said that he was in the restrooms, so there's no reason he's sitting on the back of us.
What did we do on this?
You ordered a warrant for no. He stepped outside, so I think he can.
Come on up. You just have a seat up here, sir. Thank you. In the jury box, right up here. And that was, I'm going to need to get his file again. Oops. Who is this? Mr. Brooks.
He had.
Okay, what are we doing today? On this,
Mr. Ham's case, are you just asking for more time?
Yes, yes.
okay, he's not yet, right? How much time are you asking for, man?
There is a co-defendant for this case. I think his next court date is April 20th. So how about we ask for?
I don't like that. We gotta do one direction, one way or the other. It was indicted in September. It's a third-degree felony of theft. I don't see any prior convictions here. But
I think there's a chance that they may be asking one side to give testimony on the other side and working it out. That's why I think they're trying to set it for the same date as the co-defendant. I think, is it a trial that the co-defendant set for? I don't know.
Mr. Boyd, you're on that?
No, that's
Mr. Hams.
Okay, it says Daniel.
Call it.
stood in for my.
Well, Who's representing the other defendant? Do we know?
Daniel.
Who?
Daniel.
It's out now, he's here later.
So there's a second indictment here
Yes, sir.
on. Okay, let's pull that if you don't mind. And we're going to need another indictment. Let me look at that other indictment on this other defendant. Yeah, we're getting him.
He's asking about the co-defendant.
Yes, sir.
Then we'll,
It's like. I'll print it.
And it appeared yesterday on this matter, Judge.
I remember somebody, they were from Las Vegas.
Yes, sir. These are the two individuals from Las Vegas involved in this. That individual has a attorney by the name of Brandon Zarate.
I printed the reset too.
So on this one, what do you say?
What was the question?
Why do we need to reset on an announcement?
Well, I've given both defense counsel a proposal as to how to.
When was that handed out?
Yesterday for the.
Yesterday?
Today for this.
Okay, well, they got to take some time to review that
And
if it was yesterday.
I just released discovery to her today, so I know she needs an opportunity to review it.
Oh, no, they gotta have some time. How much time do you need, ma'am? How much?
2 months.
2 months?
Yes.
Okay, so March, end of March, good?
Yes, sir.
When did we set the other one?
April 2nd.
All right, I'm gonna do it for both on
fine,
that
good.
day,
Want it together?
April 2nd. Okay,
Thank you, Your Honor.
is that good? All right, get a resetting. Thank you.
I think the cases now, they're,
Uh,
cases are linked in the system now.
okay, that's good.
Um,
So we had this man, and who is, which, come on up, Mr. Brooks. Who is your attorney?
I'm trying to hire.
Wright Kimbler?
Yeah. I'm trying to hire one of them.
Okay. Give me a status on this.
I believe the probation officer left, but earlier this is the one where she said he was, for us to file a motion and she's going to get that to us because he'd been testing positive for cocaine. I believe
Okay.
that's what it was.
You've been testing positive according to the probation officer. I've ordered a motion, an amended motion to revoke probation to be filed. There's a pending motion you pleaded true to. And we dealt with that back in August. And now she says these positives are showing up. And we're going to move fast on that. So just buckle up, be ready. But when that motion gets filed, there will be a warrant issued, and then we're going to have a hearing quickly. And just know that. And your lawyer we've been having some difficulties getting him up here on matters. And either he's going to be up here or you're going to have to get another lawyer. But I expect him to be up here. This is a case that I'm not going to take a lot of time on. We're going to move forward on this because that's evidence of free falling. That needs to be dealt with. So anyway, get her resetting. Yes, here.
And we just request that he be tested, Your Honor, for drugs just because he's been.
All right, I'll get the probation office to test. Oh, yes. That motion, what's his bond on that motion right now?
We released him. He did 60 days up front and was released to continue probation. Waiting for. It was just a review today, held in abeyance.
Okay, so we technically don't have a motion pending anymore.
Yes.
That one is
In abeyance.
that we held him and continued, that's still pending.
Yeah, so they're gonna file a first amendment, administrative hearing, ask for this, do a first amended answer.
What's his bond on that right now?
He's not out on a bond. He was just released from custody to continue with probation after the upfront.
Well, if he tests positive here, we're going to put him in
You can set
custody.
a bond. Okay, we've got something. Okay.
Okay, Mr. Walker, let's come on up, sir. Thank you for waiting.
Good morning, Judge.
Good morning to you, sir. Thank you for waiting. We had these other matters that were fires that we had to fight, that we needed to deal with, and thank you for being patient.
Yes, sir.
On this case, this is cause number 14-19966. The state of Texas versus Calvin Gary Walker. Mr. Walker was placed on probation. That probation was revoked. He has appealed the revocation of that matter, and we are awaiting the disposition from the Court of Appeals on that. Meanwhile, he was granted a bond on the appeal, essentially for the purposes of repaying the restitution that was owed based upon the jury decision and the court's determinations. And what I want to know is where we are on all of that. The last time we had a hearing, we ordered the disposition of properties to be transferred over to the Beaumont Independent School District that the defendant had owned. And I want to know what the status is on that. I haven't heard anything. I haven't heard anything one way or the other. But I want to make sure that all the transition of the properties were going into the Beaumont Independent School District coffers, and for the people, the taxpayers, to be relieved of some of this indebtedness. And also, what is the status of Mr. Walker's payments toward restitution, which was the major reason that the court allowed a bond on his appeal. And where are those? That's what I'm curious. From probation, can you please, Ms. Sandra, give us an update on all of this? I have something dated January 21st.
Yes.
That you've sent. And has the defense gotten a copy of this? No.
No, I'm sorry, Judge. I didn't know if you were asking me.
Yeah.
I've I have a budget sheet that Mr. Walker filled out. I don't know if that's what you're referring to.
No, this is what I'm referring to as
No,
this
sir.
notice. Okay, let me make a copy.
Or email it to him.
Okay, we're gonna get this over to you right now. What it shows is, it looks as though restitution, the defendant has paid over $12,000 to the Beaumont Independent School District so far. That is not including the real properties
No, sir. It's not
that
included.
have been ordered, transferred, and that's what this part of the report that you're about to get.
Okay.
It shows a financial determination, and I'm just sending you the cover page. I'll get the other. It looks like 5 supplemental pages, which consist of the defendant's payments that are made to the probation office since his supervision began.
And I had seen that probably not updated for the last 2 months, I'm guessing, Judge, before our last setting.
Yeah, this is dated January 21st, 2 days ago.
Okay.
So, yeah, but
Did you want a status on the appeal while we're waiting for that email, Judge?
I do.
Sure.
Yeah.
I'll get you the exact dates if you need, but about 50 days ago, I filed the appellate brief. The state's was due end of December. They did request a 30-day continuance. Their due date should be coming up in the near future. I'm not really positive who's handling the appeal for the state. I'm guessing they're not in there with you, Judge, but their due date should be around February 1st. And then, as far as the property, we were also wondering, I think last time we were here, we had a monetary amount we assigned, which was the tax valuations, and we didn't know how that was going to get credited either. So it sounds like you're already looking into that.
So what do we know from the state on that? Anything?
Judge, I apologize.
No, you're Ms. Nealand.
Angela Nealand is handling the appeal. It's actually being finished up today. It should be filed at the beginning of next week for purposes of informing him.
Come on up. So he can.
Sorry. Again, I apologize.
No, you do us the honor.
Angela Nealand's handling the appeal. That'll be finished today and filed early next week. And obviously it covers a myriad of issues that they've raised, including the property, the original revocation, a bunch of different issues, of course. And all of that is working its way through the system. So obviously we have a concern that we don't want to do anything to disrupt the appeals process. But as far as the property valuation, we haven't really been involved in that because obviously we were opposed from the beginning, but I know he signed over some things. We later discovered after the hearing, there was a quite substantial tax delinquent bill attached to those. But again, we're not involved in that. I don't have any information with regards to that because we haven't looked into it or been part of that.
Thank you.
Well, that's gonna, I don't know how we're gonna resolve it, but it's gotta be resolved somehow if but the Beaumont Independent School District, their leadership has always stated they want to recover all that they can from Mr. Walker on his obligations that were dealt with in this trial. And so the court is running out of assets of the defendant to turn over. And that those two properties, if there are tax consequences, those are going to have to be dealt with, and that's going to have to be resolved to net what is going to be determined that will be transferred over in monetary value to BISD. What's being done about that? I don't think I'm supposed to do it, but what are we supposed to do?
So Judge, from Mr. Walker and my perspective, we signed the quitclaim deeds. I stuck around, made sure they got filed with the proper clerks. And I think you actually helped me out with that. I can't remember what the issue was, Judge, but we got those filed. I don't think that he owns the properties anymore. And so if anything else is needed to transfer those, let us know. But my understanding is, BISD owns those properties. I think it's 3 properties now. I mean, that's what
yeah,
I'm not a property lawyer, but I remember from law school, I think a quitclaim deed transfer that to BISD just as you had asked for, Judge.
Okay. Well, he will obviously be given whatever credit if there's tax indebtedness. I've never figured a way to prioritize over the tax man. I don't know how that is supposed to work, if it's possible, but taxes are going to have to be excised out of that value. And then whatever the remaining value is, the court will intend to give fair credit toward Mr. Walker's obligation. And if there's an issue on that, we'll resolve it.
Okay.
Y'all about it. But I haven't heard anything yet myself about what has been done in taking the tax obligations, if they exist, out of that. But I understand there is. I haven't looked into
that. Was our information was there was a substantial tax.
What we'll do is somebody I'm going to ask if the state would call BISD and see where they are in the recoupment of the value on those properties, and what net has been determined based upon tax obligations, which are always prioritized. But whatever is not taxed is going to get credited toward Mr. Walker's obligation under the court order in this case. So,
Judge, could I just mention one thing? I know we always have a record with your wonderful court reporters there. I'm going back off memory right now, but I thought what we had done for the purposes of restitution and being paid is we agreed on a much lower number, we being Mr. Walker and I, than he thought it could be sold for. I know it wasn't selling for what he had it listed. And we were hoping, it was our understanding that that number that we had on the record last time was what we were going to apply to his credit towards his restitution. And I don't have the number in front of me. I think it was 280,000, something along those lines. I just wanted to mention that was our understanding of what had happened at our last setting, and I am going off my memory.
Well, whatever the credit's going to be, it's going to be a new arithmetical determination. Okay. It's going to be what it actually becomes when the numbers are put together and the taxes are taken out. And then if there is another issue, then I'll resolve it if it has to get resolved. But until Yeah, fair market value is, I think that's back in law school. One of the first things we learned in property, right? What a willing buyer is willing to pay and a willing seller is willing to sell it for. And whatever that meets, that's fair market value. And if that can't be determined, it just can't stay in twilight zone. The court will make a determination in abundant fairness and based upon input of all the parties. And if I have to resolve it, then I'll make a resolvement, and then that can be an issue that can be taken up later. But it's going to get resolved one way or the other, as expedient as this court can do it, and in all fairness possible to all parties, the obligor and the obligees. So, yeah, but I just, I don't believe it's been, of course, what would answer it is the properties, somebody comes up and says, we want to buy those properties. And then that becomes a fair market value determination if that can be, if an agreement can be reached. So that's what he would be given credit for there. That's an easy one. The question then becomes, if they're just sitting there and they're not transferred but to a willing buyer, then obviously it just doesn't sit there in twilight zone. It has to get resolved in all fairness, to a defendant and to the people. And we take that up if and when that happens. But there are answers to it. It's going to be done one way or the other. And everybody knows when we're dealing with these things, these can be excruciatingly time continuing, where we can't get things done immediately or quickly as we would want. But the importance is the assets that the defendant did have been, that can be transferred, have been moved over to the taxpayers.
That's right, Judge. And I think we did that yesterday, or I'm sorry, last setting.
Yes, and that was what was most important for this court.
Okay. And again, that is those values which this court understands are significant amounts. We expect ultimately to be liquidated or given credit to the defendant for. The other is what he has been doing as he promised, and that was pay monies while this pay as much as he could toward the balance on restitution, which is a lot of money. 6 figures plus. And we have over $12,000 applied toward restitution, not counting those properties which were on the tax appraised of over a couple $100,000, I believe. But the defendant made promises. Mr. Walker has promised from the outset of this that he is willing, ready, and able to work, and had opportunities from friends or others, acquaintances, to help him make income to pay the minimum of $1,000 per month that he has ordered. That's not being done. Oh, I thought he was paying that.
Well, as of today, $12,194 has been paid, and over the time that we have, from the time that we have ordered this, that doesn't factor out to $1,000 a month, but let me finish. What I want to know is, are you meeting that obligation of $1,000 per month?
Yes, I have.
Yes, sir, at least. If you can pay more, you can pay more. All right. So that's what I'm concerned about. That's good. That's okay.
Okay.
Because that has been since that order.
Yes.
That's important. The next thing is, are you able to pay more than that?
Not at this time.
What is being done? Because you represented, the opportunities were there to make an income that was more than just $1,000 a month if he paid for restitution, because this court has ordered a minimum of 1,000, but I want as much as you're able to pay to the taxpayers.
That's what I've been doing.
So what are you doing to be able to pay more than $1,000 a month? And are there is there any hope of anything soon being accomplished in that regard to increase this?
Let him know about the two home warranty companies, Calvin.
Yeah, I've applied for several jobs and I got a couple of contract offers with Choice Home Warranty and American Home Shield. But I only get the job if they call, they have to need my assistance at the time.
Since when has that been an opportunity for you? Since when? How long have you been waiting?
About a week ago. I applied for
Okay.
several jobs.
Okay. Well, so what are y'all thinking about? Where does it look on that? What's realistically hopeful?
I think that my understanding is currently with his limited income he's getting from his son's company, and I think this has all been reported to Miss Hunter, I believe, and his Social Security payment that he receives monthly. I think he's still the last month or two when he's paying the increased amount of 1,000. I believe he's been borrowing a certain amount to get to the 1,000, to be upfront with you, Judge. And I believe that has been reported to Ms. Hunter. And if he can get more money and so he doesn't have to borrow from friends, I think that he could then pay. I used to have American Home Shield insurance. I thought it was a waste of money on my side, but hopefully they'll get him some work to come out there. I could never get anyone to come out to my house, but that's not his fault. That was American Home Shield's fault, quite frankly. But I think that Mr. Walker's doing what he can. I know he'd also sold those trucks before the last setting and paid that money to the county for BISD as well. So, Judge, I don't think I have a definite answer other than right now he's still borrowing some amount of money to make that 1,000 each month. And if he can make more than $400 or $500 additional money, he could probably start throwing a little extra on top of the newly ordered 1,000.
Okay, well, your less than hopeful review of your past experience with that organization doesn't give me a lot of hope.
Well, that was on the insured side, Judge. So,
what state saying? Anything you'd like to add?
No, sir.
All right, and all the appeals briefs have been filed?
They will be at the beginning of next week, and then it's entirely in the hands of a different set of judges to decide what to do.
All right. The appeals brief from the state's going to be filed here shortly.
Yes, sir.
So it'll be in the hands of the Court of Appeals, and hopefully an opinion will be determined, a resolvement will be determined expediently.
Yes, sir.
Until then, the defendant continues to be ordered to pay at least $1,000 per month toward restitution payable to the Beaumont Independent School District. And I am not aware of any other assets he personally owns that can be acquired and ordered by the court to pay. Is that what everybody believes? that with the properties from Pleasure Island that have been ordered, turned over, then it's his homestead period that he's left with. Is that what everybody states? Mr. Walker, right?
That's correct.
So it's an income issue now in employment, and what I will do is review this and 60 days on a status and of where the appeal is and what other income opportunities Mr. Walker was able to acquire. But at the beginning of this, Mr. Walker, I'm going to remind you, you were very optimistic about being able to get employment and work for folks. And that's just not paying off. That optimism is not resulting in an income that you had proposed or expected. And I expect you to vigorously attempt to seek all opportunities for additional income so as to repay the victim in this case as much as possible. Are you doing that?
I am.
Okay. I want you to pass on to the probation office every week an update on what efforts you were making, so I can be confident and satisfied that you are making all vigorous attempts as possible. Who you've talked to, what applications you've made, copies of applications that you make. And I want that weekly. Do you understand, sir? That will be a condition of this bond. And how often do you meet with Mr. Walker?
Every 2 weeks.
Every 2 weeks. Okay.
The most recent job search.
Man. Yeah, I'm looking at something since December, which shows a job search worksheet that does the defendant fill this out, or is he telling you this and you're filling it out?
He fills it out.
Okay, this is your handwriting.
That's correct.
Okay. And how often are you getting this?
Every 2 weeks.
Every 2 weeks. Okay. And this is a product of 2 weeks right here
Since December.
since December.
It's about a month. It's about a month, Judge.
Does he fill out a new sheet each time or just add to this single sheet?
He adds to that sheet and I initial and put the date that I observed.
Okay. All right. So since December, we're looking at 8 independent entities that the defendant has contacted for job opportunities. Okay. And that's since December. Okay, that's good.
There was another sheet there.
Because this is since December 15th. And so that's that's 5 weeks, and that's less than 2 a week, you know. But you said there's more. Here. Thank you. No. Well, Ms. Hunter is pretty good at keeping bookkeeping accurate, so we got to ramp up the quantity of attempts, don't you think?
Judge, I'm seeing 2 a week since up until last week.
Yeah, it was
If I'm reading it right, 15, 17.
It was 5 weeks, 8 in 5 weeks. So it's less than 2.
Right, I'm just looking at the dates. I'm just seeing the 2 a week up through the last week.
What do y'all think about that? I mean, is that enough? Is that satisfactory? Because number one, this is nothing's being accomplished except we're making attempts, but we've got these online applications have been filed. That you file that, and that I know, I understand. And how long does that take? I know what an application doesn't take a week to do, but I can understand meeting with people might take longer after this these applications, but most of this are just online applications being filed. Only 4 meetings with particular representatives of potential employers are here. I mean, this just there needs to be more vigor, is what I'm saying, sir. I know, but I know how long it would take to do an application. It doesn't take that long. Every day, your obligation on your bond is to be striving for income every day. Well, it's arguably, it may not be vigorous enough.
Yes,
What do you think, Mrs. Munn?
As noted on some of these job searches, some places are not hiring. So Mr. Walker has been directed to apply to places that are actively hiring.
Well, he won't know until if they say we're not hiring, then he needs to move on with that. But he's picking up the phone, and if it's a dead end, you just don't drive into the dead end. You turn around and try another, and that's what I want is to be vigorous in attempting to get more income to pay the taxpayers. And I'm not sure that I'm satisfied yet on this. There needs to be more vigor. Anything else? Okay, when did we say review?
3/27. It will be about 60 days, so we'll have to.
Yeah.
Yes.
What was the date, Judge? I'm sorry, I didn't hear that.
Middle of March.
3/27.
3/27.
Can I just,
3/27.
do you mind if I check and see if that's spring break, Judge? I'm sorry.
Okay. Yeah, let us know.
Okay, I'll let you know. Your staff's been great working with me, so I think I'm good though. Thank you.
All right. Okay. Yeah. Well, in that period of time, in 2 months, there needs to be more than just that amount of online applications, which are just 8 attempts, or this court's going to act.
Okay.
Okay.
Thank you, Judge.
You think it's a mistake?
No, sir.
Thank you. We're in recess on this. Get a resetting, please, Mr. Walker. Okay, I have this man. Yes.
Yeah, and his queen.
Thank you for waiting. Sorry.
I just gotta check the schedule.
It's his phone.
He's pretty good about.
Here is. Oh.